Good morning. This is Betty Rankin Widgeon. I've been appointed by the Michigan Supreme Court to serve as the master in these proceedings, and I'd like to have counsel state your name at this time. From disciplinary counsel, please.
Good morning, Your Honor. My name is Laura Weingarten. I am one of two disciplinary co-counsels.
All right, thank you. And Mr. Helland, I believe, is your co-counsel. Mr. Helland, are you able to introduce yourself at this time?
I can do that, although I seem to have a bad internet connection this morning, but I'm here, sort of.
All right, thank you. Go ahead and state your name, please.
Lynn Helland.
All right, that was your co-counsel, Lynn Helland. Thank you. For the respondent, please.
Your Honor, Donald Campbell on behalf of Judge Morrow, and I'll let co-counsel introduce herself.
Elizabeth Jacobs, co-counsel.
Thank you, Ms. Jacobs. And I believe we are ready to begin, but Mr. Campbell, you have a stipulation before your first witness testifies?
That is correct, Your Honor, if I may.
You may.
Thank you. The stipulation involves the admission of two exhibits, one of which is the stipulation, and the other is a document upon which the stipulation is in part based. Because of this stipulation, we're able to proceed without having to call Laura Weingarten as a witness in this matter. I appreciate the disciplinary counsel, plural, working with us on this matter so that we could present the stipulation and proceed with the matter. So stipulation involves two exhibits that were not originally provided in this matter that I will have emailed to you, Your Honor, so that you have them. That email will go also to disciplinary counsel and to the court reporter, so she has them. But they have been marked now separately as Exhibit L, Respondent's Exhibit L, and Respondent's Exhibit M. Respondent's Exhibit L is a document that I'll now describe, and then it is referenced within Exhibit M and the stipulation. It's a one-paragraph memo that was made by Laura Weingarten, and it was sent to Don Campbell. It is dated October 1, 2020, and it has a ray line that says, testimony of grievant, comma, Anna Bickerstaff. And it reads as follows. Again, it is one paragraph, about 6 lines. On September 29, 2020, Ms. Bickerstaff reviewed the memo written by Detective Joanne Kinney about Detective Kinney's interview of Ms. Bickerstaff on June 17, 2019. Ms. Bickerstaff had not previously seen this memo. She informed me that the memo contained an error. She said she had not informed Detective Kinney that Judge Morrow was trying to hit on her. Ms. Bickerstaff informed me that she does not know why Judge Morrow said the things he said to her. That completes the reading of the memo that is Exhibit L. Now I have Exhibit M, which is longer. It's about a page and a half, but it's larger type, so it won't take long to read. I do want to point out something here. Exhibit L contains a reference to Detective Kinney's memo. And you'll see as part of the stipulation, we agree that it's actually the memo that was prepared by Chief Bivens referring to Detective Kinney's memo and not the actual memo of Detective Kinney. So with that understanding, again, that's expressly clarified here. I'll proceed. This is Respondent's Exhibit M. It's entitled Stipulation. The parties stipulate that if Laura Weingarten were called as a witness, she would testify that she interviewed Anna Bickerstaff on September 29, 2020. During the interview, Ms. Bickerstaff informed Ms. Weingarten that there was an error in the paragraph of J. Bivens's report, page 3 of Exhibit 12, which purports to be Ms. Bickerstaff's statement. Contrary to the sentence in that paragraph, Ms. Bickerstaff told Ms. Weingarten that she had never told Detective Kinney that she believed Judge Morrow was hitting on her. Ms. Bickerstaff also told Ms. Weingarten that she did not believe Judge Morrow had been hitting on her. She informed Ms. Weingarten that she does not know why Judge Morrow told her the things he did when he came to counsel table during the Matthews trial. Ms. Weingarten has a present recollection of this conversation. Ms. Weingarten made a note of Ms. Bickerstaff's statement contemporaneously with the statement. On October 1, 2020, Ms. Weingarten prepared a memo of her conversation with Ms. Bickerstaff for the purpose of informing counsel for Judge Morrow of it. Marked as Exhibit L to FC 102, the phrase in Ms. Weingarten's October 1, 2020 memo, written as, quote, the memo written by Detective Joanne Kinney, end quote, is, in fact, a reference to the section of page 3 of Exhibit 12 to JTC FC 102 that was sent to Ms. Bickerstaff. Ms. Weingarten's October 1, 2020 memo was provided to Judge Morrow's counsel in the discovery exchange on October 7, 2020. Ms. Weingarten's October 1, 2020 memo records that Ms. Bickerstaff told Ms. Weingarten that she had never read Jay Bivens's report or the paragraph she was provided from the report by Ms. Weingarten. Ms. Weingarten would testify that she does not have a current recollection of Ms. Bickerstaff making that statement. Ms. Weingarten's practice is to attempt accurately to record what a witness says to her. Because Ms. Weingarten has no current recollection of Ms. Bickerstaff making that statement, she cannot provide the circumstances of the statement, such as the question she asked or Ms. Bickerstaff's exact words to her. For that reason, while Ms. Weingarten believes her memo accurately describes what she understood Ms. Bickerstaff to say, she is unable to ensure that Ms. Bickerstaff accurately understood her question and she accurately understood Ms. Bickerstaff's answer. The October 1, 2020 memo is a recorded recollection of the information Ms. Weingarten received from Anna Bickerstaff. The parties stipulate to admit the October 1, 2020 memo as Judge Morrow's Exhibit L. It is not written on the stipulation, but we also agreed to admit the stipulation that I just read.
That's correct, Your Honor. Both exhibits, we don't object to their admission.
Thank you. So I would move for admission at this time of Exhibits L and M.
Thank you,
No-
counselors.
No objection.
They are admitted. Thank you. All right, at this time, I think we are ready to call in your first witness from the waiting room.
Yes,
Ms.
please.
Campbell and Ms. Jacobs, and that person is Ms. Gabi Silver. So I'm going to admit her at this time.
Thank you.
And Ms. Silver, if you can hear us, please unmute your microphone. Thank you. Are you
Yes.
able to hear? You're able to hear us?
I am, thank you.
All right, thank you. My name is Betty Widgeon. I am the hearing master in this matter, and we are going to start with me swearing you in today. I'm going to give you the usual oath, and then I'm going to talk to you about the sequestration order that you are under as a witness, and also the witness protocol for this proceeding. Raise your right hand, please. What is your name?
My name is Gabi Silver.
And please spell that.
Yes, it is Gabi. Last name is Silver, Silver.
All right, thank you, Ms. Silver. The oath is this. You may keep your hand raised. Thank you. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
All right, thank you. With respect to the sequestration, this order and the sequestration will remain in effect until witnesses are released from it by the master or until the proceeding before the master concludes. To be clear, this means that the order remains in effect even after a witness testifies, unless the witness is released by the master or the proceeding ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing her testimony in any format or by any means with another witness, from viewing the proceeding on any device, from listening to the proceeding on any device and accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to discovery of the failure or violation. Do you understand that?
I do.
All right, thank you. There is a second order having to do with witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you're testifying?
I am. I'm in my office. My door is closed.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until this proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist them in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand that order?
Yes, I'm turning my phone off now.
All right, thank you. And do you swear or affirm that you have abided by those orders and that you will continue to abide by those orders unless and until you are released from those orders or the proceedings end?
I do.
All right, thank you. Ms. Jacobs, anytime you're ready, please.
Thank you, Judge. Good morning. Would you state your name again, please?
Yes, Gabi Silver.
Would you please tell us a little bit about your background and your profession?
I am a criminal defense lawyer. My office is in Detroit. I have been a practicing attorney since July of 1984. I can't even believe it, but July of 1984. And I practice in a small office with my husband. And we have another attorney that works for us. We share space with two other lawyers. As I said, my practice is all criminal defense and has been probably for the last 30 years.
Do you practice in, I'm going to call it recorder's court again. Do you know what I mean by recorder's court?
I do, fondly. I know it as recorder's court. I do. I practice federal court. I practice throughout the state of Michigan, but primarily in Detroit in recorder's court.
In your practice since 1984, have you observed that the outcome of a case sometimes is dependent on the judge to whom it is assigned?
Sometimes I think not only the outcome, but maybe the whole experience, I guess I would say as well.
Do some judges exhibit a concern for protecting the constitutional rights of defendants more than other judges?
Yes, I would say so.
Some judges sentence more harshly than other judges?
Yes.
Do some judges have a reputation for assuring more than other judges that a trial is fair?
Yes.
I want to turn now to the assignment of cases in Recorder's Court. After the bind over from district court, how is a case assigned to a trial judge?
Cases are assigned randomly, computer assignment. And if there is a co-defendant who comes through the district court later, they would go to whatever courtroom has already been assigned to the first defendant.
Do you know why there is this kind of, if I said blind draw, does that sound familiar to you?
Yes. I would imagine for fairness.
Is there a system of alternate judges at the court?
There is.
Can you explain it to us?
Yeah, so sometimes if a judge can't hear a particular case, maybe they know one of the parties involved, it might go to an alternate. Sometimes if a judge isn't available on a given day to hear a case, sometimes it goes to an alternate. I have had situations where certain motions have been heard by alternates because maybe I'm doing a bench trial with a judge and the prosecutor and I agree that maybe we don't want our trial judge to hear the motion. So there's any number of reasons why it might go to an alternate.
And is the alternate a designated alternate?
Yes.
Okay. And tell me your answer.
I'm sorry, I'm talking over you. I'm sorry.
No, I'm talking over you. Go ahead.
Let us hear that question again, Ms. Jacobs. I didn't get that question.
Sorry. Is there a particular alternate assigned to a particular judge?
Yes, each judge has an alternate assigned, always, the same alternate, always.
Our visiting judge, strike that. Is there a system that our visiting judges used in Recorder's Court?
They are.
Is a visiting judge assigned to a particular judge's docket?
Sometimes.
Is the visiting judge an alternate?
I wouldn't consider them to be an alternate, but they are sometimes assigned to specific dockets. Sometimes they are brought in to help clean up when there's so much work in that building. And sometimes visiting judges have been brought in to help try some of the backlog of cases.
Were you involved in the case of People versus James Matthews? The number is 18-7023.
No, I don't even know. I don't know who that even is.
I want to turn your attention to the case of People versus Felix Antoine Jones Hill, case number 19-3777. Are you familiar with that case?
Yes, that case I know. That was my client and my case.
What was the charge in that case?
It was first-degree murder, assault with intent to murder, various gun charges. I don't remember what else, but a number of very serious charges.
Who was the assistant prosecuting attorney on that case?
The assistant prosecutor was Ashley Chiffone.
Was she working with anybody on that case, any other attorney?
She did when it came to trial. Preliminarily, it was just her. At trial, she had Bergamo. I can't remember how to even say her name. A newer lawyer.
Was your client in this case awaiting trial on, or was he on bond?
He was in custody.
Do in custody defendants get preference over not in custody defendants in terms of trial dates?
They should, and they typically do.
Before Friday, July 12th, 2019, what judge was Felix Jones Hill's case assigned to?
It was assigned to Judge Morrow.
And was that by this blind draw that you mentioned?
I think it wasn't by the blind draw. I think that the co-defendant on the case had gone through the exam prior to my client, actually significantly prior to my client. He had been arrested before my client, and he was before Judge Morrow for a significant amount of time, as I remember, awaiting trial. My client was arrested later. He had his preliminary examination a significant time later, and then I think was put on someone else's docket, but immediately moved to Judge Morrow so that he would be with his co-defendant.
Is that consistent with the rules as you know them?
Yes, always.
Before July 12th, 2019, had you had any court dates before Judge Morrow?
I think we had, I know that the co-defendant had a lot of court dates. I think I had 1 or 2 court dates before Judge Morrow before July 12th.
Had you done any motions before Judge Morrow?
No,
Were you given a trial date by Judge Morrow?
yes.
What was that date?
Can I look at my docket sheet? Is that all right? I don't remember without looking at my docket sheet.
Would that refresh your recollection?
It would.
Please look at your docket sheet.
Thank you. It was scheduled for September 23rd, 2019.
After July 15th, 2019, on or after July 15th, 2019, did you discover that the case had been reassigned?
I did.
Tell us about that.
I really don't remember how I was first made aware that the case was reassigned, but I did receive, at some point I received a motion moving to disqualify Judge Morrow. We were waiting to have some kind of hearing date on that motion. And then I received an email from a prosecutor, Anna Bickerstaff, who, for all I knew, wasn't involved in this case, indicating that our case had been reassigned to a different judge.
Do you recall what date that email was sent to you?
I don't. It was sometime the middle of July, and it had an order attached to it reassigning the case. The whole thing was extremely strange and uncomfortable and infuriating and disappointing, frankly. But anyway.
Before we get to that, can I have slide 15, please? Would it refresh your recollection as to the date that you received the order and notice that a motion had been granted in your case if you reviewed the email from Anna Bickerstaff to you?
Yes, please.
Okay, it should be appearing on the screen shortly. Do you see it?
Yes, I do.
And does that refresh your recollection as to when that order was sent to you?
Yes, it was July 15th, 2019.
Do you recall the date of the order?
The date of the order was July 12th, if I remember correctly.
Can you tell us how you felt about this case being removed from Judge Morrow's docket?
Objection relevance.
Response, Ms. Jacobs.
Judge, I'm asking her as an attorney. She's representing a defendant who's been given a trial date. He's in jail. He has a September 23rd trial date. I'm going to establish that that trial date doesn't follow him. So I would think that this is very relevant.
Judge, my response is that the chief judge has the authority under the Michigan court rules to transfer cases to other judges, and how Ms. Silver feels about that is irrelevant.
The circumstances of this, may I, Judge, respond? Yes. The circumstances of this transfer are very peculiar, and that was what Ms. Silver was going to talk about.
All right, thank you. Objection is overruled. You may answer the question.
Can you tell us what you thought about this transfer?
First of all, I thought it was extremely odd that a motion had been filed to recuse a judge and no hearing had been held as far as I knew. My client and I were directly impacted by it. There was a motion that was filed, people's motion, that had my client's name on it. And there was never a hearing conducted on it that I was aware of. I don't know how that happens. I've never had that happen in all the years that I've worked at Frank Murphy Hall of Justice. Has that ever happened? So some kind of hearing happened. I wasn't a part of it. My client, who was charged with homicide, wasn't a part of it. My co-counsel wasn't a part of it. The co-defendant wasn't a part of it. And then I receive a notice with an order from a prosecutor telling me that my case is being transferred to another judge that she's already contacted to set a date. I mean, talk about the appearance of impropriety, forum shopping. I don't know how that happened. I still don't know how that happened. I still don't know if there was a hearing. And then I am expected to explain to my client how we start out with one judge and poof, we're in front of another judge. I was very upset by it. It bothered me tremendously. I've never seen that happen at Frank Murphy Hall of Justice. And I hope I never see it again, frankly.
Did you, in that July 15th email, were you told who the new judge was?
I was. And I was told to appear on a specific date by a prosecutor, not by the court, not by a clerk, but by a prosecutor, who, as far as I knew, had nothing to do with this case. And in fact, I think that may be the only thing she had to do with the case, was she set a date, told me to be there.
Do you remember the name of the judge it was assigned to?
Yes, it was assigned to Judge Michael Hathaway.
And what was Michael Hathaway's status at this point?
A visiting judge.
He was not the alternate to Judge Morrow.
Judge Hathaway had retired and he was a visiting judge.
Thank you. Did there come a time when someone from the court staff, the administration, contacted you about this case by email?
Yeah, but that was later. I mean, that was after we had already made appearances in front of Judge Michael Hathaway.
Do you remember the date of that email?
I don't.
Would it refresh your recollection if you saw a copy of the email? Slide 16, yes. If you'll just wait a minute.
Judge, I just wanted on the record that I have not received copies of the prior email that was shown or this one that they're going to be showing. I'm not objecting, but I just want it known that it was not given to me in discovery.
Thank you. That is noted for the record.
If we could just have a minute, we're trying to get slide 16 up. Do you recognize this email, Ms. Silver?
I do.
Does that refresh your recollection? Does that
yes,
refresh?
It does. Oh, it does. August 22nd, 2019 is when we received that email. But we had already had numerous appearances before Judge Michael Hathaway before getting that. I don't know what in the world that's supposed to be for, what it means or why we got it.
Was this your first notice from anybody in the administration of the court concerning the transfer?
Sort of. I mean, like I said, we had already been in front of Judge Michael Hathaway at that point. So I really didn't understand that email, nor do I understand it at this point.
Do you know who Amber Taylor is?
I do.
Who is Amber Taylor?
Amber Taylor is the court clerk. Well, she was at that time, to Judge Lawrence Talon.
And Amber Taylor was the person that sent this August 22nd email to you, correct?
Yes.
Judge Talon is not Judge Hathaway.
No,
Do you have any idea why she sent this to you?
not a clue.
In that email, did she give you another date to appear before Judge Hathaway?
Yes.
Thank you. If I can just have a moment to catch up to myself, Judge. You mentioned that you subsequently saw this motion to disqualify.
Yes.
Is there anything on that motion that indicated that it was ex parte?
No, there was no date on the motion. It didn't say it was ex parte. It said that there was a supplemental filing, which I never received, and no notice of hearing.
And you're looking at this motion right now, is that
Oh,
correct?
sorry, I am. I'm sorry. I was looking, I'm not used to this testifying stuff. Yes, I was looking at the motion.
Judge, we just want to point out that this is Exhibit I believe, and we'll be moving to admit it at the end of the case.
What is that exhibit number?
I,
Thank you.
alphabetically. Did you ever see, strike that. Did you ever receive a proof of service of this motion?
Not that I recall.
Would it refresh your recollection if you looked at the docket entries?
Sure, but I'm just saying, even I did look at the docket entries. I don't ever remember seeing the proof of service. And frankly, I don't even really remember how I received the motion. In other words, when motions on a given case get filed, they are somehow magically forwarded to the lawyers. I really don't remember how I received that one. I do know at some point I got it because I remember, trying to do some research and trying to figure out what this motion was really all about and speaking to Prosecutor Chaffone.
Are you familiar with the court rule on motions to disqualify judges?
Yes, sort of. I am after this case when I tried to prepare to have a hearing on this matter.
Is an affidavit required in support of the motion?
I think so.
Did you ever see an affidavit attached to this motion?
No, and I never received, in the motion itself, it talked about a supplemental filing. I never received that either.
Let's turn now to your experience practicing before Judge Morrow. You have practiced in front of him, is that correct?
I have.
Can you estimate for us how many trials you've had before him?
I don't know, 10, 20. I don't know.
Have you spent time in his courtroom waiting for your case to be called, observing other work going on in the courtroom?
I have.
Have you observed Judge Morrow's demeanor?
I have.
Did you think there was anything wrong with his demeanor? Or can you tell us about his demeanor, please?
The thing I think that I respected most about Judge Morrow was his fairness to all parties, his respect for everybody who came in the courtroom, whether you were the defendant or a lawyer. He treated my clients with respect, like they were real people, as he did their families, as he did families of the victims. He tried to make them feel comfortable in the courtroom. He, in spite of what was going on, you know, I mean, a lot of times very serious charges, you know, it's hard. I don't know. I don't see that kind of respect towards my clients, particularly in other courtrooms, towards my clients, litigants, family members on both sides. I thought that was something that always stood out to me, as opposed to some of the other courtrooms where, you know, clients, family members, victims aren't usually or aren't treated quite so well.
Have you observed his interaction with defense counsel and prosecutors?
Yes.
Does he treat them differently? That is,
Not that I saw. No, not that I saw, but I can tell you it was, sometimes it was equal treatment if you were doing your job, and equal treatment if he didn't think you were doing what you should be doing for your client or your respective party. You were called out on it as a defense lawyer and as a prosecutor.
Does he treat male and female lawyers the same?
As far as I saw, yes.
Have you ever heard him use sexually graphic language in an inappropriate manner to attorneys?
I have not.
Is there anything in his interaction with counsel for both sides that would erode public confidence in the judiciary?
Not that I ever saw.
You ever heard him or seen him question women attorneys who appeared before him about their physical appearance?
No.
You ever seen him overtly eyeing women attorneys?
No.
Thank you. I have no further questions of this witness.
Thank you. Are there any questions on cross-examination?
Yes. Ms. Silver, you've known Judge Morrow for almost all of your 30 years of practice. Is that fair to say?
I've known, I don't know how many years, but I've known Judge Morrow since he was an attorney at the public defender office when I was a practicing attorney in Recorder's Court. I don't know how many years that is, but a long time.
Over 30, right? Is that fair to say,
Maybe.
over 30?
I don't know if it's over 30, but definitely, well, let me think about this for a second. I started really practicing in Frank Murphy probably in 1990. So since that time.
All right. Now, you testified that you received information that your case had been transferred, and the first you knew of it was an email from Anna Bickerstaff with a order from Judge Kenny attached. Is that fair to say?
That's correct.
Do you have the order from Judge Kenny in front of you?
Yes.
Judge, that is the order that we referred to the last time we were in session. The people were going to move to admit it. It will be marked People's Exhibit 15, and I will email it to you a little later.
All right, thank you.
Ms. Silver, you can refer to it if you need to. Who is the order signed by?
It looks like it's signed by Judge Tim Kenny.
Who is Judge Tim Kenny?
He is the chief judge of the Wayne County Circuit Court.
And what is the title of the order?
Transfer order.
What date is on it?
It says at a session of said court held on July 12th, 2019. Pre-trial July 19th, 2019. That's what it says.
And does it say that he's transferring the judge from Judge Morrow to Judge Michael Hathaway?
Yes, it does.
And under the section that says reason, does he cite a court rule?
He does.
What court rule does he cite?
He cites MCR 8.110C3A.
Have you had an opportunity to review that rule?
I have.
Do you in fact have it in front of you?
No, but I can.
Okay, if you would please put it in front of you.
See. Okay.
Have you had an opportunity to review that rule?
I have.
Do you agree that the rule provides that Judge Kenney has the authority to transfer a case from one judge to another?
I do.
So you're not testifying that Judge Kenney did anything unethical or against the rules. Is that fair to say?
I guess I can't really testify to that because it appears that there were a lot of things that went on between the time the prosecutor's office filed a motion seeking a different judge and the date of entry of this order. A motion was filed with my client's name on it. Some kind of hearing was conducted, and I was not a party to it, nor was my co-counsel, nor was my client. So I cannot testify to what anybody did that was proper or improper, since I was not given the ability to be present at any hearing that was conducted.
You don't know that a hearing was held on the motion to recuse Judge Morrow, do you?
No, this was all top secret, it appears. I don't know anything. I know
Is
a
it
motion was filed by, the prosecutor, which resulted in me and my client and my co-counsel and his client getting transferred to Judge Michael Hathaway. That's all what I know.
Is it possible that a hearing was never held?
I have no
Objection,
idea. How would I know?
What is the objection, Ms. Jacobs?
calling for speculation. Is it possible?
Any response, Ms. Weingarten?
Well, she's been an attorney in the building for 30 some years, and it is possible, she can answer whether she has information about that or not.
Thank you. Objection is overruled. You may answer.
I would have no idea if a hearing was held. Clearly, something was going on behind the scenes. When I attempted to elicit information from the prosecutor that was handling this case, I was told she wasn't talking about it. When I asked for the supplemental pleading that was supposed to be attached to the motion, I received nothing. When I asked when the hearing date was going to be scheduled, I received no response. What I did get was an order.
What is the name of the prosecutor you're referring to?
Ms. Chiffone.
She told you she didn't want to talk about it?
She told me specifically that I could talk to her supervisor.
Did you in fact talk to her supervisor?
No, I didn't. I asked for a date for a hearing, and I prepared to conduct a hearing on my client's case.
Do you have any evidence that Ms. Chiffone or her supervisor or Kim Worthy, the elected prosecutor, had anything to do with choosing the judge to whom the case was reassigned?
How would I know that? I have no idea what happened behind the scenes as it relates to this matter.
So the answer to my question would be no, I have no evidence.
The answer would be I have no idea. A motion was filed and an order was entered on July 12th. That's all I know.
Given the way the rules work, do you agree there is no room under the rules for anyone from the prosecutor's office to have any input into who the case is reassigned to?
Oh, I can't, I don't know what you're talking about, frankly. What rules are you referring to?
Well, the Michigan Court Rule 8.110, the Chief Judge's Rule.
Okay, so I don't know. I can't answer that. I have no idea. I'm not going to speculate.
Well, do you have any evidence that anyone in the prosecutor's office picked the next judge?
I have no idea. As I indicated before, I fully expected that a motion that was filed would have had a hearing before a judge. That's what I, no, I'm not done. That's what I fully expected and understood would occur, is once a motion is filed, a hearing would be scheduled. And it wasn't. So the entire process was contrary to everything I knew about how things operate in a court system. So what happened or didn't happen beyond that, I don't know.
Is there anyone in particular that you blame for the process not working the way you expected it to?
I don't know who is responsible for how the process occurred. I know that when I file a motion I schedule a hearing. That's what I do. I don't get to forum shop or, cut corners. I mean, I file motions asking for relief and motions are heard. I don't know what happened here. I've never seen this happen before.
So is it fair to say you have no evidence that anyone from the prosecutor's office did anything unethical or wrong? Is that fair to say?
I'm going to object. It places a burden on this witness that she has not got. She doesn't have to have evidence.
Well, she's claiming that there were all sorts of improprieties, and I want to know who she's putting it on.
Objections overruled. Continue.
I have no idea, Ms. Weingarten. I know that a motion was filed and no hearing was ever scheduled that I knew of, that I was permitted to participate in, that my client was permitted to participate in. And the next thing I knew is I received an order from a prosecutor, not a courtroom, not a judge, but from a prosecutor. So how that happened, what phone calls were made, I don't know. I have no idea.
Would you have been less upset if Judge Michael Hathaway's courtroom or Judge Kenny's courtroom had been the ones to notify you and send you the order?
I would have been less upset if the rules would have been followed. If a motion that was filed by the prosecutor would have had the appropriate documentation with it, and that a hearing in an open courtroom would have been scheduled so that my client and I and my co-counsel and his client could have participated in the motion that was filed in our case.
Judge, I would ask that you strike that answer as unresponsive. My question was, or we could have the court reporter read it back.
Please.
All right, let's have the question. Ms. Jorgensen, please.
Would you have been less upset if Judge Michael Hathaway's courtroom or Judge Kenny's courtroom had been the ones to notify you and send you the order?
And her answer was not responsive, Your Honor.
I would suggest to the court that it was within the framework of that question. That was a broad question deserving of a broad answer.
All right. So the objection by Ms. Weingarten that it was not responsive is sustained. And I will ask the court reporter to, for the official record, strike that answer. Continue.
So I'm going to ask you the question again, and this requires a yes or no answer.
Sure.
Would you have been less offended if you received notice that the case had been transferred from Judge Michael Hathaway's courtroom or Judge Kenny's courtroom?
No.
Do you have any insight into the factors that Judge Kenny used in ruling that the case should be transferred?
How could I speculate on that? I have no idea what happened.
You don't know if he looked at the workloads of the judges, the alternate judge, as well as Judge Michael Hathaway, do you?
I have no idea. I know a motion was filed. We never had a hearing. That's all I know.
Do you have any evidence that Judge Kenny conspired with anyone in the prosecutor's office to take the case off Judge Morrow's docket?
I have no idea.
Do you have any evidence that Judge Kenny conspired with anyone in the prosecutor's office to transfer the case to Judge Michael Hathaway's docket?
I have no idea.
By the way, you don't have any problem with Judge Michael Hathaway, do you?
I really, if you want me to answer that, I will. I was very concerned when the case was transferred to Judge Michael Hathaway for a number of reasons. One of those reasons is that I was unable to explain to my client what occurred. The second reason was that I find Judge Michael Hathaway to not be he's not as personable and respectful to the litigants and to clients. And the third reason would be that at that time, when it was transferred to Judge Michael Hathaway, I was representing a young man who had been charged with sexually assaulting Judge Michael Hathaway's step-granddaughter. So yes, I was very concerned when the case got transferred to Judge Michael Hathaway.
So this other case that you're referring to, a sexual assault, did it have anything to do with your client, Mr. Felix? I don't have his whole name right here with me. Did it have anything to do with that case?
No, but I was concerned that because of my representation of the young man and the familial relationship of Judge Hathaway to the complainant in the matter, I was very concerned that that would be one more reason that myself and my client wouldn't be treated fairly.
Did you move to disqualify Judge Hathaway on those grounds?
No, I was about to move to disqualify Judge Hathaway, even though I've never moved to disqualify a judge ever. But I was going to do that. But fortunately, after testimony, the case was not bound over.
So if it was at the examination, I'm sorry, go ahead.
I think it was shortly after the case was transferred to Judge Michael Hathaway that we had the preliminary examination and the case was dismissed after testimony. And I'll tell you that Judge Michael Hathaway questioned me about it a couple times when I went in his courtroom, which in front of the litigants and other parties in the courtroom, and it made me quite uncomfortable. So that's what I think about Judge Michael Hathaway.
Now, you have no evidence that anyone in the prosecutor's office had input into selecting Judge Hathaway as the judge who would try your case. Is that fair to say?
Asked and answered. Objection,
Yeah.
asked and answered.
Okay. All right, we're going to move on now and talk about your testimony about Judge Morrow. You testified on direct exam that you've never heard him use sexually graphic words to an attorney, right?
Correct.
And that you've never heard him ask women about their appearance, women lawyers about their appearance, right?
Correct. Do you believe you provided opinion testimony about Judge Morrow? No, I was asked if I had ever seen or heard Judge Morrow do those things, and I don't think that's opinion testimony. Okay. Would you agree that you're not in Judge Morrow's courtroom every minute of every day? Of course not. Are you familiar with the art that's on Judge Morrow's walls in the courtroom? Yes. Tell the judge about the Bill Cosby picture that used to be on the walls.
Objection, assumes a fact not in evidence.
We've already had testimony that there was a picture of Bill Cosby after his conviction on the wall.
I'm not sure that that testimony was as strong as Ms. Weingarten believes, but also there's no evidence that this particular witness saw that picture.
Well, that's why I asked.
Well, then my objection is compound question.
All right, Ms. Weingarten, can you clarify your question for this witness, please?
Yes. Have you in the past seen a picture of Bill Cosby on Judge Morrow's courtroom wall? I have, along with many other beautiful paintings I have definitely seen. Would you
Yes.
agree there was a beautiful painting of former President Barack Obama?
Yes.
Would you
Rosa
agree there was,
Parks.
I'm sorry,
And Rosa Parks
and Martin Luther King?
and lots of prison art. Yes.
Would you agree that the Bill Cosby painting was posted next to the witness room door where witnesses come in and out of?
I'm trying to remember where that painting was. I don't remember where that painting was.
Do you remember whether,
I want to say it was by the, I don't remember. I really don't remember.
do you remember there being words painted on the painting?
I remember the face of Bill Cosby and maybe a TV. I don't remember the words.
Do you recall there, I'm sorry, I didn't mean to interrupt you.
I'm trying to remember. I don't remember the words, if there were words.
You don't remember the words, or you don't remember if there were words?
I don't remember if there were words. What I see when I see it was a larger painting. I see Bill Cosby and I see a TV set, if I am remembering it correctly.
If I said the words, would you recognize them?
I don't remember if there were words. I mean, I don't remember. Can I see it? The painting? Do you have it?
I do not.
No.
Defense counsel may. I guess they can do that and redirect if they choose. All right, now, one moment, please. Judge, may I have a moment to consult with Mr. Helland?
Certainly. Do you want to take a 5-minute break at this time, or do you need more time?
5 minutes is plenty.
Ms. Jacobs, does that work for you?
Yes, please.
All right, thank you. We'll take a 5-minute break and then we'll come back. It's 2 minutes before 10. Let's come back at 5 after. Thank you. Everyone, please mute your screen. I think everyone is back. Are you ready to proceed, Ms. Weingarten? You're on mute. You are muted at this point. And Ms. Silver, you are also muted. Thank you.
I was hoping there were no more questions for me, so I figured I'll just stay on mute.
Where am I? Judge on your screen? I don't have me on this. Hold on. Let's see if we got it. You're there. You don't need to touch anything. You don't see myself. You're there and you're muted.
Anytime you're ready, Ms. Weingarten, but you are muted. Please unmute.
There. Okay.
All right, thank you.
We have no other questions of Ms. Silver.
All right, thank you. Ms. Jacobs, any redirect of this witness?
Just briefly. Mrs. Silver, you recall the motion to disqualify that we talked about earlier?
Yes,
Do you remember what court rule that motion was based on?
it was, can I look at it so I can get the right number?
Yes.
Yeah. Okay.
There's
It
no
was,
objection. She looks at it.
No objection.
it was based on 2.003, disqualification of a judge, which is, you know, like when we were trying to get ready for our motion hearing that we thought was coming, that's what we were researching and looking through, disqualification of a judge.
So that motion does not reference Michigan Court Rule 8.110.
It does not.
I have, Judge, let me just make sure. You talked about your discomfort with Judge Hathaway because his granddaughter was a complainant in a case. Is that correct?
That's correct.
Did you have to cross-examine his granddaughter?
I did. In fact, yes, I did.
Okay.
And the district court judge, based on her testimony, refused a bind over. Based on, yes, my cross-examination.
When you talked about in your testimony about a case being dismissed, you weren't talking about the murder case in front of Judge Hathaway. You were talking about this other case.
Oh no, that murder case didn't end quite so well for my client and I, but I'm talking about the other case, the case that involved Judge Hathaway's step-granddaughter. That case was dismissed following her testimony at a preliminary examination.
This is going to be my last area of direct. Does Recorder's Court use electronic filing?
Yes,
If you file, or when you file a motion, the other side is served electronically, is that correct?
that's correct.
Thank you. I have no other questions of this witness.
Nor do
Thank
I.
you. All right, thank you. May this witness be excused?
Yes.
Yes.
Thank you, everybody. Stay safe.
Thank you. Ms. Silver, we're going to excuse you. Please remember you're still under the orders that I talked with you about, sequestration. And the other one had to do with witness protocol. There's some possibility that you may be recalled, but you are excused at this time. Thank you.
Okay, thank you very much.
Judge, I will call my next witness, Nicole James, but I have to get my file first, if I may.
All right, one moment. I do not see that person in this waiting room.
I'll make a call.
Let us have a sidebar for just a moment, please. I have a room that we will go into. All right, counsel, it appears that Ms. James is in the waiting room. I will let her in at this time. Good morning, Ms. James. Can you hear us?
Good morning, yes.
All right, thank you. My name is B Widgeon. I am the hearing master for this matter, and we are going to start with me swearing you in. Please raise your right hand. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
All right, thank you. And please state your name and spell it for me.
I apologize, I didn't hear you.
Please state your name and spell your name for us.
Nicole James, Nicolejames.
All right, thank you. Ms. James, there are two orders that relate to the witness's conduct for this proceeding, and I'm going to read those to you. I'm going to find out whether you have abided by those orders and whether you are swearing and affirming that you will continue to abide by those orders. The first one is called the amended sequestration order, and it reads as follows. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master or the proceeding ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing her testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and from accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude the witness or to exclude testimony given by that witness prior to discovery of the failure or violation. Do you have any questions regarding that order, ma'am?
No, Your Honor.
All right, thank you. The second one having to do with witness protocol at the hearing. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room at this time?
Yes.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand that order?
Yes.
And do you do you swear or affirm that you have abided by those orders and that you will continue to abide by those orders until released or the proceeding is concluded?
Yes.
All right, thank you. Ms. Jacobs, you may proceed. Ms. Jacobs, do you mean to be muted?
Mr. Campbell controls this. I'm not allowed to touch it. He is now taking care of it. Good morning, Miss James. How are you?
Good morning. I'm fine. How are you?
Fine, thank you. Can you please tell us a little bit about yourself?
I'm an attorney. I've been in private practice for the last 6 years. Prior to that, I worked at the Wayne County Prosecutor's Office for 15 and a half years.
Can you tell us what division did you work for in the prosecutor's office?
I worked in the domestic violence unit, preliminary exams in district courts, homicide unit, general trials, juvenile. I think that may cover, and appeals,
Did you try a lot of cases?
lots and lots of cases.
Did the people in your office tell you that winning the case was very important?
Say that again, I'm sorry.
Did the people in the prosecutor's office, the people you worked with or for, did they tell you that winning the case was very important?
I don't know that anyone said that. I took my job seriously, so, and for me, winning was important.
Did the office itself keep track of your wins and losses?
Yes.
Did murder cases matter more than other cases?
I don't know. I don't know about that.
Did you ever do a serial murder case?
No.
You appeared in front of a lot of judges, I imagine, in those 15 and a half years?
Yes.
Would you agree with me that not all judges are the same? That each has their own idiosyncrasies?
Agreed.
As a new prosecutor at the office, and we're talking about the Wayne County Prosecutor's Office, is that correct?
That's correct.
Did people in your office tell you what to expect from certain judges?
Yes.
Were you told anything about Judge Morrow?
Objection to, if she says anything beyond yes or no, it's hearsay.
Judge, this is intrinsic to our particular defense. That is that the prosecutor's office have trained their prosecutors to view anything that Judge Morrow does with contempt. And they have been looking all along for reasons to file complaints against him. In fact, my next series of questions would be about keeping a book on Judge Morrow.
Excuse me, Ms. Jacobs, the objection is sustained. Would you like to make a separate record?
Yes, please.
Great, thank you, Ms. Jorgensen. Let us know when you are ready. You're muted right now, Ms. Jorgensen.
Thank you, Your Honor. Just a moment, I'll get the question.
Thank you.
Okay. And I should repeat the question, Your Honor?
Yes, please.
Okay. Were you told anything about Judge Morrow?
So can you answer that question, Ms. James?
Yes.
Were you told anything about Judge Morrow by people in the prosecutor's office?
Yes.
Tell us what you were told.
That basically Judge Morrow wasn't a good judge. He didn't follow the law, not a nice person. And so anything that happened in there was scrutinized. And so anything that happened in that courtroom, you could come back and we would go back and report to our supervisors regarding what happened.
Do you remember the name of your supervisor at that time?
I know this is crazy. I only had one case in Judge Morrow's courtroom. It was a homicide case. but I'm not sure whether I was in domestic violence when that occurred, because I did homicides and domestic violence, or whether I was in the homicide unit. So it would have either have been Piper Fakir, or it would have been Robert Stevens and Athena Syringas.
Did you then adopt this view, and this is still on the separate record, Judge? Did you then adopt this view of Judge Morrow?
Yes.
Did you view everything he did through that lens, that he was a bad judge?
Yes.
Did you make a strike that? That's the end of my separate record, Judge.
Could I cross-examine, Your Honor?
I'm sorry.
Yes.
Ms. James, you worked for the prosecutor's office up until 2014, is that correct?
Yes.
And your testimony is that your office kept track, the prosecutor's office kept track of wins and losses?
Yes.
Did you get raises if you won a case?
No.
Did you get bonuses if you won a case?
Under Mike Duggan, there was a bonus system based on units and stats.
Okay, is it fair to say Mike Duggan stopped being the Wayne County prosecutor in 2004?
Yes.
And then Kim Worthy became the elected prosecutor after that?
Yes.
So under Kim Worthy, did you get bonuses if you won a case?
No.
Did you get demoted if you lost a case?
Not that I'm aware of, no.
Okay. And you say that the prosecutor's office kept a book on things that they think Judge Morrow did wrong. Is that fair to say?
Judge,
Yes.
I think we're still on a separate record, and I'm not sure that these questions are relevant to the separate record. I just want to make sure we're all on the same page.
Well, I'm cross-examining her about things she said on the separate record that were on direct exam.
I just want to make sure that the judge, that you're aware that I still have more direct examination of her.
Definitely.
Thank you.
Okay. So are you familiar with the Michigan Supreme Court case in Ray Morrow, 496 Michigan 291, a 2014 opinion?
No.
Are you aware that the Michigan Supreme Court was asked to review Judge Morrow's work when the Judicial Tenure Commission held a hearing in 2013?
No.
Judge, I'm going to object. I'm not sure how relevant this is to the separate record since this witness left in 2014.
Well,
and that opinion.
Ms. Weingarten, go ahead.
Okay. The testimony on the separate record was that she was told by people in the prosecutor's office that he's not a good judge, he doesn't follow the law, and that they should scrutinize everything and report things to their supervisor. And I'm going to confront her with the Michigan Supreme Court opinion, which shows that he in fact did not follow the law and multiple times and was not a good judge. But she's not aware of this opinion, so I want to read parts of it to her.
Ms. Jacobs, any further objection?
I think, Judge, we have to establish, and this might be my error, when she was told this about Judge Morrow. Was it at the beginning of her appearing in being a prosecutor, or was it at the very end? Because this is only relevant if she didn't know about Judge Morrow's reputation until the very end. Then it's relevant.
The objection is overruled. You may continue, Ms. Weingarten.
Ms. James, were you aware that the Supreme Court held Judge Morrow responsible for closing his courtroom without complying with the governing court rule, and he impeded the proper administration of justice?
No.
Were you aware that the Supreme Court held Judge Morrow responsible for refusing to follow mandatory statutory language after it was brought to his attention and it evinced a willful failure to observe the law? which eroded the public's confidence in a fair and impartial judiciary?
No,
Were you aware that he disregarded a superior court order directing him to hold a hearing and he didn't?
no,
Were you aware that he recasted a previous order dismissing a case without prejudice to justify his sua sponte dismissal of the case after it was reissued, despite the defendant's intention to plead guilty?
no,
Were you aware that Judge Morrow failed to recognize the limits of his adjudicative role when he subpoenaed a defendant's medical records without the party's knowledge or consent?
no,
Were you aware that Judge Morrow recklessly placed himself and others in his courtroom at risk of serious harm by personally bringing a defendant convicted of several violent crimes from the lockup and sentencing him without restraints or courtroom security present?
I was aware of that, yeah.
Were you aware that Judge Morrow showed, the Supreme Court said Judge Morrow showed poor judgment by coming down from the bench at the start of a trial to shake hands with the criminal defendant and deliver papers to his counsel, which at a minimum created the appearance of impropriety?
No,
Assuming that all those things have been found to be proven, do you believe that the prosecutor's office had a right to keep a book on him and to keep track of bad things he said and did relating to cases?
yes,
Does it make sense that the prosecutor's office pays attention to how judges in general rule?
yes,
Because how judges rule affects whether a motion should be filed or what plea offers to make or whether to have a bench trial or a jury trial, right?
yes,
If a judge makes rulings that seem biased against the prosecution, wouldn't it make sense that a prosecutor's office would pay especially close attention to things that judge does?
yes.
Judge, I have no other questions for the separate record.
Thank you. Ms. Jacobs, do you want to continue in the separate record at this time?
No, I want to go back to the real record.
All right. Ms. Jorgensen, let us know when you're ready. And you are muted, Ms. Jorgensen.
I apologize. Judge, I apologize. I guess I do have more for the separate record.
All right. Ms. Jorgensen, let us know when we're ready to continue with the separate record.
Moment, Your Honor. Okay, we are ready. Thank you.
Judge, I'm not sure whether this is relevant to both records, so I'll ask this question here and then go back and ask it again.
All right.
Ms. James, when were you told by people in the prosecutor's office that Judge Morrow was a bad judge?
I don't remember the exact date.
Do you remember if it was at the beginning of your practice with the prosecutors, in the middle, or in the end?
I would say, I know for sure it wasn't at the beginning, so I would say more towards the middle.
And again, can you tell us what years you worked at the prosecutor's office?
1999 to 2014.
So are you estimating it would have been about 2007 that you were told that Judge Morrow was a bad judge?
I would say probably around that time.
Thank you. Maybe go back to, I apologize if does Laura Weingarten have any questions? Otherwise, back to the original record.
No, I have no other questions for the separate record.
Thank you. Ms. Jorgensen, let us know when you're ready for us.
I'm ready, Your Honor. Thank you.
Thank you. Ms. Jacobs, continue.
Thank you. Ms. James, can you tell us when it was that you were told that Judge Morrow was a bad judge?
I don't remember exactly. I know it was not at the beginning of my tenure at the office. So I would say somewhere in the middle.
And would you tell us what years you worked at the prosecutor's office?
1999 to 2014.
Would it be fair to say then that you were advised about Judge Morrow in 2000, somewhere around 2007.
Yes, somewhere around there.
When you first started to work at the prosecutor's office, who was the prosecutor, the chief prosecutor, the elected official?
John O'Hare.
And did there come a time that Mr. Duggan was the elected prosecutor?
Yes.
Can you tell us what dates you worked under Mr. Duggan?
I cannot tell you those dates. I don't remember when he was in office and when he left.
Do you remember when, well, Kim Worthy was a judge. Do you remember when Judge Worthy became the elected prosecutor?
I remember when she became the elected prosecutor, yes.
And when was that?
I can't tell you the year. I apologize.
Was it before 2007?
I would be guessing. I don't know, honestly.
Thank you. Would the disciplinary council stipulate that it was in 2004?
Well, I'm not sure. I know she was appointed by the circuit bench in 2004 to take over for Mr. Duggan, and then she ran at the next election.
Let's go to when she was appointed to take over for Mr. Duggan.
January of 2004.
Thank you. Ms. James, can you tell us what kind of practice you have now?
I do criminal defense, family, and probate.
Do you practice in recorder's court? First of all, do you know what I mean when I say recorder's court?
I'm assuming you mean Frank Murphy, but Third Circuit Court.
That's a criminal division of Wayne County Circuit Court, is that correct?
Correct.
Do you practice in front of Judge Morrow?
Yeah.
And you're now practicing as a defense attorney, is that correct?
Correct.
Have you had the opportunity to appear in front of him several times since you've become a defense attorney?
Yes.
Based on these experiences, can you tell us if you have formed an opinion about Judge Morrow that is different from the one you held when you worked at the Wayne County Prosecutor's Office?
Yes.
Can you tell us what that opinion is?
I think Judge Morrow tries to be fair. I think he's, friendly, which is something I didn't think before, but I think he tries to be fair.
Does he treat women the same as men? If you've been able to observe that?
Yeah.
Have you ever heard him use sexually graphic language inappropriately?
No.
Will you describe Judge Morrow's voice to us?
I would say he has a deep, booming voice.
Thank you. I have no further questions of this witness.
Your Honor, with permission, I would like to go over some things that were on the separate record, but I think should be on the regular record.
Certainly.
We would object.
Well, you may start. There might be an objection from Ms. Jacobs. So we'll see what your questions are.
Okay. Ms. James, you testified on the regular record that you were told by people in the prosecutor's office that Judge Morrow was a bad judge. Is that right?
Yes.
And you learned that sometime around the middle of your career there, maybe around 2007.
Yes.
And your opinion of him as a defense attorney now is different from that.
Yeah.
Your opinion now is what, that he's a good judge?
Yes, I think he tries to be fair, and that's all you can ask for.
You also testified earlier that the prosecutor's office kept a book about things Judge Morrow did wrong. Is that right?
Yes.
I'm going to ask you some questions about that. Were you aware that many prosecutors' offices keep track of how judges rule?
No.
But you are aware that the Wayne County Prosecutor's Office kept track of how Judge Morrow ruled?
Yes.
Did they also keep track of how other judges in the Wayne County Circuit Court ruled?
Never. I never heard about anybody else other than Judge Morrow.
You never heard about Judge Deborah Thomas and how they kept records on her and how many times she was reversed by the Court of Appeals?
I wasn't. I know about that, but I don't know that. I know that from know that there was a book. So specifically whether there was a book.
A book about Judge Deborah Thomas?
I'm sorry, say that again.
I'm asking, when you say there was a book, what are you referring to?
I knew that there were things that were happening in Judge Thomas's courtroom. I wasn't aware whether it was a book or not, but specifically with Judge Morrow, I knew that they were keeping a book.
And you also knew that they were keeping track of Judge Deborah Thomas's decisions also, right?
Yes.
And is it possible there were other judges they were keeping track of?
Yeah, that's possible.
Object calls for speculation.
Any response, Ms. Weingarten?
We can strike that.
Stricken?
Does it make sense that the Wayne County Prosecutor's Office pays attention to how judges rule?
Yes.
And how judges rule affects things like whether to file a motion in a courtroom or what plea offers to make or whether to have a bench trial or a jury trial, right?
Yes.
Wouldn't you expect that to be standard operating procedure in every prosecutor's office concerning every judge?
I only know about Wayne County, so I'm not sure how to answer that.
If a judge makes rulings that seem biased against the prosecution, wouldn't it make sense that the prosecutor's office would pay especially close attention to what that judge does?
Yes.
I'm going to object to the use of the word bias. The Wayne County Prosecutor's Office finds that whenever a judge rules in favor of a defendant, that shows bias. So I think that Ms. Weingarten should have to define her terms.
Well, I think now Judge Attorney
Jacobs
James is testifying that every time the prosecutor's office lose, they claim bias. There's been no testimony about that.
All right, so the objection again, Ms. Jacobs, is?
I think we need to define the term bias.
Ms.
Because
Weingarten?
may I continue with my record, Judge?
Well, yes, you may. I just wanted to get her response to defining the term, but go ahead and finish. I'm sorry, I didn't mean to cut you off.
I just wanted to add that one denial of a motion does not bias make.
All right, thank you. Ms. Weingarten, any response?
Judge, I can rephrase the question to avoid the issue with the word bias.
Thank you.
Ms. James, if a judge makes rulings that seem favorable to the defendant and unfair to the prosecution, wouldn't it make sense that the prosecutor's office would pay especially close attention to what that judge does?
Yes.
Were you aware that the Supreme Court reviewed a Judicial Tenure Commission proceeding that went to a formal hearing in 2013, and they rendered an opinion March 5th of 2014 entitled In Re Morrow, 496 Michigan 291?
No.
I'm going to read to you some things and ask you if you were aware of these things. Were you aware that the Supreme Court ruled that Judge Morrow's closing of his courtroom without complying with the governing court rule impeded the proper administration of justice?
No.
Were you aware that the Supreme Court said that Judge Morrow's refusal to follow mandatory statutory language after it was brought to his attention evinced a willful failure to observe the law, which eroded the public's confidence in a fair and impartial judiciary?
No.
Were you aware that the Supreme Court said that his disregard of a superior court order directing him to hold a hearing also eroded the public's confidence in a fair and impartial judiciary?
No.
Were you aware that the Supreme Court ruled that Judge Morrow's recasting of a previous order dismissing a case without prejudice to justify his sua sponte dismissal of the case after it was reissued, despite the defendant's intention to plead guilty, degraded the integrity of the judicial process and the judiciary itself?
No.
Were you aware that the Supreme Court ruled that Judge Morrow failed to recognize the limits of his adjudicative role when he subpoenaed a defendant's medical records without the party's knowledge or consent?
No.
Were you aware that the Supreme Court ruled that Judge Morrow recklessly placed himself and others in a courtroom at risk of serious harm by personally bringing a defendant convicted of several violent crimes from the lockup and sentencing him without restraints or courtroom security present?
Yes.
Were you aware that the Supreme Court ruled that Judge Morrow showed poor judgment by coming down from the bench at the start of a trial to shake hands with the criminal defendant and deliver papers to his counsel, which at a minimum created the appearance of impropriety?
No.
So assuming that the Michigan Supreme Court ruled the way I read those things to you, would you agree that the prosecutor's office had every right and every duty to keep a log or a book of errors and mistakes Judge Morrow made?
I'm going to object. Compound question, right and duty.
I can rephrase
Unless-
the question, Judge.
Yes, please rephrase.
Ms. James, would you agree if the things I read to you are true, that the prosecutor's office had every right to keep track of decisions Judge Morrow made in order to either report him to the Judicial Tenure Commission or to appeal his decisions?
Yes.
Do you agree that they had not only the right, but the duty to do so?
Yes.
Now, you told us that you've never heard him use sexually graphic statements that are inappropriate in court. Is that fair?
Yes.
Has he ever asked you about your height or your weight?
No.
Has he ever asked you about your muscle mass?
No.
Has he ever mentored you and tried to teach you how to be a better trial attorney?
He's given constructive criticism before, yes.
When he gives that constructive criticism, does he use sexual analogies?
No.
I have no other questions.
Thank you. Ms. Jacobs, additional
Thank
questions?
Ms. James,
Yes.
what race is Judge Deborah Thomas?
African American, Black.
Relevance.
I'm sorry?
Black.
What?
Wait, hold on. I object to the relevance.
Any response, Ms. Jacobs, to the objection?
Yes, Judge. Part of our theory is that Judge Morrow is being attacked because he is an African American, and that the Judicial Tenure Commission makes, I don't want to say make a habit, but they tend to file grievances or file complaints more often against African Americans judges.
Judge,
And the Wake County Prosecutor's Office makes the complaint.
My response is, Judge, up until this very moment, none of the witnesses who have testified were asked anything about racial issues. And suddenly race is now a part of this case.
Up to this point,
This question to Ms. James was irrelevant.
up to this point, no other judge has entered into this hearing. The prosecution is the one that brought out that Deborah Thomas had been complained of by the prosecutor's office at the Judicial Tenure Commission, or with the Judicial Tenure Commission.
So may I respond to that? I did not say that Judge Deborah Thomas was complained of to the Judicial Tenure Commission. I don't know that to be true. And even if it is true, it's confidential. What I asked was about the fact that she has been reversed by the Court of Appeals.
All right, thank you. I'm going to sustain the objection, but you may make a separate record if you would like.
Thank you. Separate
Would you
record,
like-
please.
All right, thank you. Ms. Jorgensen, let us know when you are ready.
One moment, Your Honor.
Certainly.
Let me grab the question just a moment. And the question was, Ms. James, what race is Judge Deborah Thomas?
All
Would you
right.
please?
You may answer the question, Ms. James.
African American.
And what race is Judge Morrow?
African American.
Judge, I just wanted to answer that in defense of my asking of the question. I should have added that I thought the question had to do with keeping book on. The number of times that the prosecution appeals decisions by that particular judge. And that's the end of my separate record.
I have one question on cross-examination, if I may.
In the separate record, yes.
Ms. James, what race is Prosecutor Kim Worthy?
African American.
Thank you, nothing further.
All right, thank you. We will go back into the main record. Ms. Jorgensen, let us know when you are ready.
I'm ready, Your Honor.
Thank you. Ms. Jacobs, continue, please.
Ms. James, every time a judge finds against a prosecutor in terms of a motion or an objection or at a sentence, are they necessarily always wrong?
No.
Thank you. I have no further questions.
I have nothing further.
All right, thank you. May this witness be excused, counselors?
Yes.
Yes.
All right, thank you, Ms. James. We're going to excuse you, allow you to leave the meeting at this time. Remember, you're still under those orders that we spoke of when I swore you in. All right?
Okay. Thank you. Thank you.
Mhm. All right. I would like to take a 5-minute break at this time. And before we do, let's go into the sidebar room one more time, counselors. Let me open up that room for us. We are going to take that 5-minute break at this time, and then when we come back in, we will have the testimony of the next witness from the respondent. Remember to mute your microphones.
Oh, what did I do with my glasses? There. I got this in 12-point type rather than 14. I can't even see it.
And again, everybody is live.
Everybody is what?
Live.
I believe we are all back at this time. Ms. Jacobs, are you ready for me to bring your next witness in?
Yes, Judge.
All right.
Put your mask on.
Oh, sure.
Ms. Hughes, are you able to hear me at this time?
Mm-mm. Judge will take care of that.
All right.
Are you able to hear us now?
Yes.
Yeah.
Thank you. Ms. Hughes, are you able to hear me at this time?
Yes, I can. It's Kennedy Hughes, though, Your Honor.
All right, thank you. I wasn't sure of that, so thank you. Ms. Kennedy Hughes, I am Betty Widgeon. I am the master appointed to hear this matter, and we're going to start with me swearing you in. Please raise your right hand. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do affirm, yes.
Thank you, and please state your name and then spell it for me.
My name is Joan Kennedy Hughes. It's capital Joan KENNEDY-HUGHES.
All right, thank you. Ms. Kennedy Hughes, I'm going to also read to you portions of 2 orders that have to do with witnesses. These are orders that you as a witness are under unless and until you are released from this order by the master or until the proceeding ends. So I'm going to start with the one having to do with sequestration of witnesses. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master or the proceedings ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing her testimony in any format or by any means with another witness, from viewing the proceeding on any device, from listening to the proceeding on any device, and from accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to discovery of the failure or violation. Do you have any questions with respect to that order?
No, ma'am.
All right, thank you. The second one has to do with witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you are now?
Yes, Your Honor, I'm alone.
Thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in their testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you have any questions with respect to that order?
No, I have no questions.
All right. So if you have a cell phone with you at this time, you would need to turn it off.
I was instructed to turn it off before I started this whole process.
Thank you.
And I obeyed.
Thank you. So you do then affirm or swear that you have abided by these orders and that you will continue to abide by them unless and until you are released from the order or the proceedings end. Is that correct?
That's correct, Your Honor. I do affirm, and I have turned everything off.
Thank you. I appreciate that. Ms. Jacobs, we are ready whenever you are.
Thank you, Judge. Could you state your name again, please?
My name is Joan Kennedy Hughes.
Would you tell us a little bit about your education and your family?
I have a master's in communications. I have my workforce development certification, and I have my career development facilitators certification. I am in workforce development. I have one daughter, and I'm single. I forgot that part.
Can you tell us who you're working for now?
I currently work at Covenant House of Michigan. It is in Detroit on Martin Luther King Boulevard.
And what do you do for Covenant House?
Covenant House is a homeless shelter for youth between the ages of 18 and 24. My position, I have the honor of helping them to find employment so that they can move out of the current process of homelessness. I help them find viable employment and help them move through the employment process to make sure that they stay there within 90 days and a year.
Thank you. Did there come a time earlier that you began working at the Recorder's Court, the criminal division of Wayne County Circuit Court?
Yes.
Would you tell us about that?
Well, I started first working there through an agency for Judge Strong. Then I left that assignment and I was informed of a position with another judge at the time. And I went and sat in the courtroom, Judge Bruce U. Morrow, and I viewed his courtroom for about 2 weeks before I approached him about a position.
What position were you applying for?
The judicial assistant position.
Do you remember what year you applied for this job?
It had to be around 2005.
What were the duties of a judicial assistant?
Each courtroom I realized varied, but with Judge Morrow, it was a very open and learning. I did all kinds of things. I answered the phone. I helped with the correspondence that came from the defendants. I helped with the jury orientation. I was allowed to sit out and view the courtroom, the proceedings. I did all kinds of things. I traveled with him to the various prisons when he did presentations. I accompanied him he did presentations and meetings with the probation office. It was varied.
It was varied.
It
Was that your-
varied, yeah.
Okay. You mentioned that you went to prisons with him. How did that, what did you do at the prisons?
Well, I set up the actual meetings when they would call and ask for Judge Morrow to come out and speak at their prisons. I had to make sure that he had the right clearance to get in, and I also went to make sure that everything went smoothly.
What did Judge Morrow do when he was in prison?
He did speeches. He did, I call them encouragement, inspirational speeches to help the young men that were in prison to know that there's hope once they get on the other side.
Did there come a time that you resigned your position with Judge Morrow?
Well, I
Strike that. Let me go back.
yeah.
Did you also have Judge Morrow speak at Covenant House?
Yes, recently Judge Morrow spoke at Covenant House, I think August. I contacted him in June and he came out in August, yes.
Was he paid for this?
No, he never asked for money. We couldn't afford him anyway.
What was the talk on at Covenant House, if you recall?
Well, he did a lot. Well, he told them a lot of inspirational things that he always does, but he also let them know what they need to do in order to get out of the system that they're in. He took questions and answers. He did all kinds of uplifting things for the youth.
Did there come a time that you resigned your position with Judge Morrow?
Formally or informally?
And were there 2 times or just one?
Informally, I did leave, but then I came back because Judge Morrow came in and spoke with me, and then I decided to formally put in a resignation, yes.
During the gap between your two work stints with Judge Morrow, what did you do?
The first time I studied for the first time I went and I did volunteer work at the St. John Riverview Hospital as a chaplain.
When did you do a formal resignation, if you recall?
2007, 2008, I think I tried to look for the letter, but I did do a formal resignation letter to Judge Morrow, and I presented it to him.
Did you send that letter to anybody but Judge Morrow?
No, I only gave it to Judge Morrow.
did there come a time that you were contacted after you resigned from Judge Morrow for a work opportunity?
Yes, I got a phone call from someone from administration. All I remember that it was a female voice, and they asked me, had I resigned, and I told them yes. They asked me if I resigned as a result of anything Judge Morrow did, and if so, they would help me find another job. And I told them no, he had done nothing. I just decided to do something different.
So they called, and what did they want to know?
They wanted to know, had I resigned from my position? And I told them yes. And they wanted to know, my resignation had anything to do with Judge Morrow? Did he do anything or say anything that caused me to leave? And if so, they would help me find another position. But I told them no, he had nothing to do with me leaving, resigning.
Were they offering you a quid pro quo? Is that what you're telling us?
Objection to the leading nature of the question.
In order to get the job, was there a condition you had to fulfill?
If the question and the statement was to me, if I left because of anything Judge Morrow said or did, they would help me find another position.
You did not resign, or did you resign because of anything Judge Morrow said or did?
Oh, no, I did not resign because of anything Judge Morrow did. He has nothing to do with my leaving.
You mentioned that someone from administration called you, but you don't recognize the name, or it was a female voice. Was that your testimony?
That is my testimony.
Could this call have originated from the Wayne County Prosecutor's Office?
Objection leading.
Objection is sustained.
Did you know what administration the person on the call was referring to?
It came from personnel.
In what agency, what division?
I thought it was Wayne County. I can't be 100% assured, but I remember it was a female voice and it was from personnel.
Did the disciplinary counsel, Laura Weingarten, ask to speak with you before you testified?
Yes, I spoke to a young lady, yes.
And when would that have been?
Was it Monday?
Is that when you recall it, as Monday?
Wait, hold on.
Are you looking at something to refresh your recollection?
I'm trying to look in my mind. It was a day I was not working. I had taken that day off. I need a calendar. It was recently, a couple of days ago.
Do you remember her asking you if you knew anybody at the prosecutor's office?
Yes, I did remember her asking me that.
And do you remember her asking if you ever applied for a job there?
No, I've never applied for, well, I have never ever applied for a job at Wayne County, but I do know Kim Worthy.
Do you remember Ms. Weingarten asking you if you have ever applied for a job at the Wayne County Prosecutor's Office? I'm focusing now on what Ms. Weingarten asked, not if you actually did.
Oh, I don't remember. I don't remember.
You observed Judge Morrow interacting with prisoners and with defendants, is that right?
Oh, yes.
Can you tell us how he treated them?
Objection.
One moment, please, Ms. Kennedy Hughes. Any response, Ms. Jacobs?
I didn't hear what the objection was, Judge.
To relevance.
The disciplinary council has charged Judge Morrow with being discourteous and disrespectful, and we're offering evidence to rebut that.
Ms. Weingarten, anything further before I rule?
The charges relate to a specific trial and two specific prosecutors, not to people in general, and certainly not to prisoners.
Judge, we can't.
I'm going to overrule the objection and allow the answer. Ms. Kennedy Hughes, you may answer the question if you remember it. If not, we can have it read back.
I have had the honor of being in the courtroom. Judge Morrow would allow me to sit over in the defendant's box. I have observed him interact with both defendants and attorneys from both sides of the desk. And I have seen nothing but respect. I've seen them laughing and joking, mutual friendship, mutual kindness. As far as the prisoners at the jail, at the prisons, they treated him as if they were friends. And these were some of the people that he had in his own courtroom, and he had to rule that they go to jail, go to prison, and they still had a friendship that blew me away. They laughed, they joked, some of them called him dad. It was different. It was amazing to me as a person that have done missionary work in the prisons. I thought it was beautiful. I liked it.
Thank you. I have no further questions.
Thank you. Are there any questions on cross-examination for this witness?
Yes, thank you. Good morning, Ms. Kennedy Hughes.
Good morning.
Can you tell us who hires judicial assistants in Wayne County?
For me, I can't tell you about the other judicial assistants. I was hired directly by Judge Morrow.
And who paid your salary?
Wayne County.
Now, you told us that Judge Morrow spoke to your group at Covenant House in August. Is that right?
I talked to him in June, yes, and he came in August.
And are we talking about 2020, this last August?
Yes, 2020.
So during COVID, he came to speak with your group?
Yeah.
Okay. So you told us that you resigned twice. Once you resigned informally, and then you returned, and then once you resigned formally. Is that fair to say?
That's correct.
When did you initially get hired?
Well, I started, we had an agreement that I would work probation, and then I did my probationary to see if we could work together. And it was a very good working relationship. And then I was officially on the payroll. I think it was October.
Of what year?
Of that year, I think 2005. So I sat in the courtroom for 2 weeks. I probationed for 90 days, and then I was hired.
So you worked for him from October of 2005, and when did you resign informally?
Let me see, that's October, November, December. Probably sometime in May or June. Probably May or June.
Of what year?
Of 2006.
So you worked with him for about 7 months, and then you resigned informally. Is that fair to say?
That's fair to say.
What does it mean to resign informally?
I just took my stuff off the walls, all my pictures and all my stuff, and I left. That was informal.
Did you give notice?
No, ma'am.
Did you tell the judge you were leaving?
No, ma'am.
What was the reason you resigned informally?
It's a very harsh environment working in the courthouse. I worked for two of the most, they claim, difficult judges. And once I told people where I worked and who I worked for, it wasn't a very good environment for me. I was not mentally mature enough to handle some of the negative stuff that happens.
Did you report any of that negative stuff to anybody?
No, I just left.
And then you say that Judge Morrow talked to you and you returned.
Yeah,
right?
I finally told him, I explained to him the negative environment that it was not a good place for me. I love the courtroom, but the work that I have to do with the other people in the other parts of the courtroom, it wasn't a good fit for me.
So when did you return?
Probably that week, that next week, a week later. If I'm not mistaken, he gave me time to think about it. And if I wanted to come back, the door was open, and I did.
So you came back sometime around May or June of 2006?
Probably so.
And then you formally resigned, you said, in 2007 or 2008. Is that right?
That's correct.
And after you resigned, you said you gave Judge Morrow a letter of resignation. And the next thing you know is that a female voice from personnel administration called to ask you if the reason you're leaving was because of Judge Morrow.
That's correct.
Did you know anything at that time about Judge Morrow's history with women employees?
You asked me that before, and I will repeat what I said. I had heard from the person who told me about the position. Her name was Betty. She worked for Judge Margie Braxton, and she is the one who told me about the position being open. She casually mentioned something about the other secretary, but she didn't go into details. I never heard anything from Judge Morrow. And when I did call Judge Morrow to tell him about the phone call I got from personnel, I left a message, but he never called me back and we never discussed it.
Well, let's talk about that message. So when you got this phone call from the female voice from administration, you called Judge Morrow to tell him about it?
I called him to let him, yes.
And would that have been shortly after you resigned in 2007 or 2008?
The former one, yes.
And did you say you left a voice message with Judge Morrow?
Yes, I left on his home number. There was a number that you could call and leave a message, and that's what I did. I didn't call the courtroom per se. I called that number that he has at home.
And you didn't reach him, but you left a voice message?
Yes, that's correct.
And you told him about this phone call that you got from a female voice at Wayne County administration personnel?
Correct.
Did you hear back from Judge Morrow after you left that message?
No.
Did you and he ever talk about that message ever again?
August, when he came on campus, I casually mentioned it and he said, oh yeah, I forgot. And that was it.
So in August of 2020, you talked to him again about that message?
Correct.
Did he tell you he remembered the message that you left him in 2008?
He just said, oh yeah, I forgot.
Did he act like he remembered it?
When you say act like, I don't know how to.
Well, did he say to you, what message are you talking about?
No, I brought it up. I told him, I said, you remember when I called you and told you about the phone message I got from personnel when I quit and they called me and offered me a job? And he said, oh yeah, I remember now. He said, I forgot, but yeah, I remember.
So he admitted to you he remembered getting your voice message in 2008?
Yeah.
And this conversation took place in August of 2020?
Yes.
What was the reason you raised the issue of the voice message that you left?
It was our casual conversation, and we had always said I worked very good, and I said, well, yeah, I shouldn't have quit. I should have stayed. And I said, oh, well, they did offer me another job. I said, remember, I called you and told you when I quit, they offered me another job. He said, oh, I forgot. Yeah. He said, yeah, I forgot. I don't know which one he put first, but he did acknowledge that he remembered, but he did also say he had forgot all about that.
You testified that you know Prosecutor Kim Worthy, is that right?
I know her and I think her daughter that she adopted, but not personally. We're not friends or something, nothing like that. I just remember when she ran for office, I remember working in the courthouse and she was there. And I think I met her once outside of the courtroom, but I'm not one of her persons on her list that she will see me on the street and say, oh yeah, that's Joan. No.
All right. So do you have any reason to believe that the Wayne County Prosecutor's Office has asked you to give them information about Judge Morrow?
Let me explain, only because of what happened before I came, I thought, or I assumed, and you know the story behind that was why they called me, but I reassured them that it had nothing to do with anything like that.
All right, so let me clarify, because you're using a lot of pronouns and I'm not sure who you're referring to. So when you say when they called me, who are you referring to?
I'm referring for the person who called me from Human Resources or personnel and offered me a position.
Did you ever have a communication with anyone who worked for the Wayne County Prosecutor's Office about a position?
No, just personnel.
So did anyone from the Wayne County Prosecutor's Office ever ask you for information about Judge Morrow?
Nope.
Did you think it was odd when the person from Personnel Human Resources called you to ask you if the reason you quit was because of Judge Morrow?
Yes, that's why I called Judge Morrow to see what was going on, and he didn't answer. But when he didn't answer, I just let it go.
Were you aware that in the year 2000 or 2001, Judge Morrow said some things to a clerk on the 9th floor of the Frank Murphy Hall of Justice that some would say was completely inappropriate?
No, ma'am, I was not aware.
Did you know that he asked a woman employee, do you have children? You should have more children. The best time to have sex is when you're menstruating. Did you know he said that to a woman employee?
No, ma'am.
Did you know that before 2004, both the State Court Administrative Office and the Judicial Tenure Commission conducted investigations into how Judge Morrow interacted with employees in the building?
No, ma'am.
Did you know that the State Court Administrator's Office wrote Judge Morrow a letter where it accused him of engaging in inappropriate personal conversation with a personnel staff person, asking inappropriate questions and making inappropriate comments?
Can you repeat that question? Because I thought I want to make sure you
Sure.
said with a staff person, with one of his staff people.
Okay, so I'll read the question again. Were
Thank
you
you.
aware that the State Court Administrative Office did an investigation and wrote Judge Morrow a letter where it accused him of engaging in inappropriate personal conversation with a personnel staff person, making inappropriate questions and making inappropriate personal comments?
No, ma'am.
Were you aware that the State Court Administrative Office instructed Judge Morrow that it is inappropriate to discuss matters of a personal nature with court staff unless that individual is an acquaintance or friend?
No, ma'am.
Are you aware that the state court administrator office instructed Judge Morrow to refrain from doing the conduct I just read to you about?
No,
Are you aware that the Judicial Tenure Commission admonished Judge Morrow in 2005 and told him in a letter, similarly, the commission cautions you against engaging in conversations with court staff which are of a personal or intimate nature and which may be regarded as offensive or embarrassing? Did you know that? No. So at the time, you thought it was unusual that a female voice from Wayne County administration personnel asked you questions. Knowing what I've just read to you, do you now understand why they asked you those questions?
I understand now, but before, no, I did not.
Objection. It calls for her to see what was in the mind of the person making the call. She can't read the person's mind.
Thank you. Ms. Weingarten, any response?
She testified that it was unusual enough to leave Judge Morrow a voice message. And my cross-examination was to have her understand why the call was made and that it was not so unusual given the circumstances.
I'm going to sustain the objection. Continue.
I have no other questions of Ms. Kennedy Hughes.
Thank you. Ms. Jacobs, any redirect?
Yes, kind of briefly, Judge.
Certainly.
Mrs. Kennedy Hughes, at Covenant, do people live at Covenant House?
Yes, to answer your question, yes.
They lived there during the time of COVID, is that correct?
That's correct. It's a homeless shelter. And one part of it is for emergency 90 days. The other part, we allow some of them that are doing very well to stay up for a year to 8 months.
When Judge Morrow came and talked, were people wearing masks?
Yes, everybody, it's mandatory.
Thank you. You mentioned that there was a negative environment. What location are you referring to?
The Frank Murphy Hall of Justice.
Is that separate from Judge Morrow's courtroom?
The courtroom is at 404, but then you have business outside of the courtroom, like the records. You have to go and get files. Weren't very nice in the records department once they found out what judge you work for. Then you would go down to the jury room because I did the jury orientations, and they were not very nice. And some of the other courtrooms were not very nice. So it wasn't a good environment for me.
How close to giving the letter of resignation to Judge Morrow was the phone call?
It had to be that next day. I thought later on that day or the next day, I gave it to Judge Morrow. The day I gave it to him, I left, and then either later on that day or the next day, please don't hold me to that, I did get a phone call.
And it was your impression that they were looking for dirt on Judge Morrow, is that correct?
Objection leading.
Was it your impression that they were looking for dirt?
I thought so. I thought so because I have put in my resignations many places and I've never been offered another job.
At any time during your relationship, working for Judge Morrow or having him come and talk to Covenant House, has he ever acted inappropriately with you?
Out of all the years that I've worked with Judge Morrow, the answer is no. He has been very respectful. I think the attorney asked me the other day if I've ever been to their home. I've never been to their home. He has only come to when I did have a place once, and that was because it snowed. He drove me to the prison, but most of the time I drive myself. He's always been very respectful, gentleman. So no, I have to be very honest. He has never been inappropriate with me.
Thank you. I have no other questions.
Thank you.
I have no other questions either.
Thank you. May this witness be excused.
Yes.
All right, thank you. Ms. Kennedy Hughes, we're going to excuse you, allow you to leave now. You're still under the 2 orders that I spoke to you about. There is always a possibility that a witness may be recalled, but you are excused at this time. Thank you.
I thank you so much, Your Honor.
All right.
Bye.
Judge, at this time, I would ask that we take Joseph Curley's testimony since he has to be offline in 20 minutes.
No objection, Your Honor. Understanding, again, it's their case on the rebuttal. I actually have a brief objection to him testifying, but understanding separate record would have to be made even if I am successful on my objection. We can do that briefly if you want to do that now.
All right. If you want to make that objection, Mr. Curley is in the waiting room, but I will not admit him at this time. Go ahead.
Thank you. It's my understanding that they wish to call Mr. Curley in rebuttal. Master will recall that Mr. Curley testified in the case in chief. My position is that's the time to ask him a question if they have a question. It's my understanding that what they're going to ask him about is nothing that was presented by the defense at any time during our case. It's my understanding they're going to ask him about something they've known about since at least February of 2020, and something they asked our witnesses about, but nothing that we have explored. So it is not properly rebuttal evidence on any course. It's also my understanding that back in February of 2020, they asked Mr. Curley the question, have you ever seen anything that was unusual in conversations involving women and Judge Morrow? And that he's going to say, well, I remember an unusual conversation about armpit hair. And that's all he's going to say. He won't say it was harassing. He won't say the person who was part of the conversation with him and with Judge Morrow was harassed in any way, shape, or form. So it really isn't relevant to anything, even if it was mildly curiosity. The disciplinary counsel throughout this proceeding has asked witnesses and has made arguments, or at least opening statements, that reflect this was unusual. This was strange. Have you ever seen a judge do this before? Have you ever seen a judge do that before? That's not what we're here about. We're not here about something that's unusual. We're here about something that is a violation of the canons or the code. So that's my objection.
Thank you. Response?
Judge, the reason we're recalling Joseph Curley in my rebuttal case is that under Michigan Rule of Evidence 405B, I am allowed to rebut testimony, character evidence that the defense presented. The defense, as you may recall, presented both Attorney Jeffrey Edison and Attorney Stephen Fishman, and they both testified that Judge Morrow, in their opinion and in his reputation, that he was a dignified, proper person. If you need me to cite to pages of the transcript, I can do that right now or not. And the testimony from Mr. Curley will rebut and give an example of something he said to a female prosecutor in his presence that clearly was not dignified and not proper.
Oh, again, Judge, Mr. Curley isn't going to say that. He's not going to say it wasn't dignified. He's going to say it wasn't improper. He's going to say it was unusual. That's all. And they know that. They know he's not going to say that. And they're not calling the person who was the other party in the conversation. So no, it doesn't do any of that, Judge.
My response is, Your Honor, as the fact finder, you get to decide whether it was undignified or improper, and if it rebuts the testimony presented by the character witnesses.
Again, they need to have a basis, Judge, and they don't have one here. They just want to throw up stories.
All right.
That
Thank you,
are
counsel.
unusual, and I'll admit it's unusual, but it's not undignified.
Thank you, counsel. I'm going to overrule the objection and allow this witness in as a rebuttal witness. Are you ready for that witness at this time?
I am.
All right, let me see. He was in the waiting room. I'm going to allow him in at this time.
Good morning.
Good morning. We've met before. You were here before as a witness, and I am going to swear you in. You are here for some limited testimony today. Please raise your right hand. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
All right, thank you. What is your name?
My name is Joseph Curley.
And please spell your name.
JOSEPHKURLY.
Thank you. Mr. Curley, when you were here before, all right, so we're waiting.
I'm so sorry.
We'll wait for Mr. Curley to take care of that. It sounds like a pet, maybe.
I think we should be okay. I apologize, ma'am.
All right, Mr. Curley, I just wanted to remind you that when you testified before, I read to you information on the amended sequestration order for witnesses and also the witness protocol. Do you recall that?
I do.
All right, and do you swear or affirm that you have abided by those orders and that you will continue to do so unless and until released by the master or this proceeding ends? Do you swear or affirm to that?
Yes, ma'am.
All right, thank you. And Mr. Curley, you are muted right now, but I'm going to ask you, is there anyone else in the room where you are testifying from?
No, ma'am.
All right, thank you. At this time, Ms. Weingarten, you may proceed.
Mr. Curley, you testified a week or so ago about the dates you were assigned to Judge Morrow's courtroom. Do you recall that?
I do.
Can you repeat for us again, what dates were you assigned there?
I was assigned there from August 2018 until March of 2020.
During your time there, were you aware of things that Judge Morrow said to any female attorneys that you thought were unusual?
Yes.
On how many different occasions?
If I may, I'm going to object to the relevance, Your Honor, on unusual, because unusual is not a charge and unusual is not a violation.
Thank you, Ms. Weingarten.
I can rephrase the question.
Go ahead.
Mr. Curley, did you observe Judge Morrow say something to a female prosecutor that you thought was improper or undignified?
I thought, there's a strange incident I was asked about that I told you about. I don't know, undignified. I don't know how to answer that question.
Judge, I still think he should be allowed to testify about that because as I argued, Your Honor gets to decide whether it was improper or undignified.
Any further response from Mr. Campbell?
Well, again, I respect your ruling that you've made that he gets to testify, but the question still has to be the proper question. That's not to talk about, did you see something unusual, is not the way to approach this. If she has a question about an incident and a circumstance, she can ask it, but she can't label it.
Judge, I can do that, but then he'll object to leading.
Go ahead, let's see.
Trust me, we're near the noon hour. It's time to eat. I don't think I'm doing that.
Mr. Curley, did you hear Judge Morrow say something to a female prosecutor about her armpit hair?
Yes,
Approximately when did that discussion take place?
I want to say summer of 2019.
Defense counsel and I have agreed to not name the female prosecutor, and I would ask you also not to name her. We're going to just to refer to her as the female prosecutor, okay? Tell us the circumstances of where you were and what was the setting of when you heard this statement from Judge Morrow.
We were in Judge Morrow's courtroom. I was seated at the prosecutor's table. The female prosecutor was seated next to me. I believe it was pretty early in the morning before court had began. And somehow a discussion of armpit hair started, and yeah.
Where were you when the conversation took place? You said at the prosecutor's table. Did you stay there?
Yes,
Were you seated the entire time?
I was.
What about the female prosecutor? Where was she?
She was seated next to me the entire time.
And where was Judge Morrow when the conversation took place?
He was standing in front of the prosecutor's table.
How far from the table?
5 feet, maybe just right in front of the table.
Did you start the conversation about armpit hair?
No,
Did the female prosecutor start the conversation about armpit hair?
no.
Who did?
Judge Morrow.
Did he share with you whether or not he shaves his own armpit hair?
Yes,
What did he say about that?
I think he said he shaves his armpit hair.
Did you share with him whether or not you shave your armpit hair?
No,
Did the female prosecutor share with him whether or not she shaves her armpit hair?
no,
Did Judge Morrow ask any questions of the female prosecutor about her armpit hair?
I believe he did.
What did he ask?
I believe he asked her what color her armpit hair was, I think.
Now, are you saying you think because you truly don't remember, or because there's another reason you don't want to say it?
No, I mean, I think the color of her armpit hair was referenced by Judge Morrow, yes. And so in February, I believe you asked me if I had ever seen anything unusual. And I said, yes, I believe he one time asked a female prosecutor about her armpit hair.
Now, did the female prosecutor have a phone in her hand at the time Judge Morrow said that to her?
At some point.
Did you have your phone with you that day?
No, I
Where
left it at home on accident from what I remember.
when you got home, did you check your text messages?
I did.
Did you receive any texts from the female prosecutor?
I did.
Did they relate to what happened with Judge Morrow involving the armpit hair?
Yes.
Now, I interviewed you about this incident in February of 2020. Is that fair to say?
Yes.
One moment, please. Did you ever report that conversation to anyone in a position of authority within the prosecutor's office?
I did not.
Do you know whether or not the female prosecutor reported it?
I don't know.
To your knowledge, was I the first one to ask you questions about that incident?
Yes.
Thank you. I have no other questions.
Thank you. Mr. Campbell, any questions of this witness?
Yes, Mr. Curley, if Ms. Weingarten had asked you whether you were aware of any times that a female prosecutor was harassed, rather than saying unusual back in February of 2020, would this instance have been one that you mentioned to her?
No,
Mr. Curley, how long was the conversation that took place when Judge Morrow is there by the prosecutor's table and you and the female prosecutor are at the table?
a few minutes, under 5.
Do you remember anything else? Sorry. Do you remember anything else that was discussed during that time other than the armpit hair?
I believe they were speaking about the color of the female prosecutor's daughter's hair, her regular hair on her head.
So, in other words, the color of the daughter's hair.
Yes,
And the female prosecutor who's there, it was wearing covering over her own hair. Is that a fair statement?
that is.
Both her armpit hair and her head hair were covered. Is that a fair statement?
That's correct.
The message that was on your phone when you got to see your phone said what?
Armpit hair, question mark.
I'm going to ask you to repeat that because it came a bit broken on my Zoom, just to make sure we got it. Could you repeat that, please?
Armpit hair, question mark.
And it was just one text?
That's correct.
Fair statement to say that you were in a position to see Judge Morrow treat people during the time that you were his, I'll call mainline prosecutor, from the dates that you've already provided, right?
I have.
Thank you. I have no further questions for this witness. Thank you, sir.
Thank you. Ms. Weingarten, any follow-up?
Yes, you said that the female prosecutor had her hair covered.
I did, yes.
Was it a religious covering or what?
It was, I believe, yes.
Do you know the name of that hair covering?
I believe it's called a hijab.
Did you see the female prosecutor texting something during the conversation with Judge Morrow?
I don't know that I did. She might have said, look at your phone. I said, I don't have it.
Do you recall that conversation taking place with her?
Vaguely.
Now, were you assigned to Judge Morrow's courtroom in October of 2018?
I would have been, yes.
Were you present when two assistant prosecutors argued a motion on the case of People versus Adrian White on October 19th of 2018?
I don't remember.
You remember whether Judge Morrow asked this one female prosecutor who was arguing the motion a hypothetical question in a non-sex related case about whether he, Judge Morrow, would have an expectation of privacy if he were to have sex in a restroom with another man?
I do remember that, yes.
Were you present when that happened?
Yes, I was.
Did you report that conversation to anybody?
No, it was in open court, from what I remember.
Have you seen a transcript of that conversation?
I have not, no.
Thank you. I have no other questions.
Thank you. Mr. Campbell?
I have a brief follow-up, if I may.
Yes.
Give me one moment to confer with my co-counsel, if I may, right before I begin.
Certainly.
Thank you. I'm going to put you on mute for a moment. I'm ready to continue.
Go ahead.
Mr. Curley, going back to that case that was just referenced, that you have a recollection of the conversation on the record, there were a series of questions asked of the prosecutor and maybe even the defense counsel relative to expectation of privacy in that case. Do you remember that?
I do remember that, yeah.
So it wasn't a sex case, but it was a Fourth Amendment search and seizure case, right?
Right, I believe, yeah.
And expectations of privacy are important to the consideration of the constitutional standards for search and seizure, correct?
Yes.
Okay. When Ms. Weingarten asked you in February of 2020 if you had seen anything unusual, you did not tell her about this particular argument in open court on a Fourth Amendment case involving a scenario and a question related to expectation of privacy, correct?
I don't remember. I don't think so. I don't think so.
Okay. Fair to say it was not unusual.
No. I mean,
No?
it is fair to say, yeah. Yes.
Thank you. Thank you, Mr. Curley. I have no further questions. Thank you, sir.
Thank you. May this witness be excused.
I have one other question for him, if I may.
All right, go ahead.
Mr. Curley, did the female prosecutor in any way ask you to get her out of that conversation with the judge?
I'm going to object to that. It's beyond the scope of my cross-examination.
Ms. Weingarten?
Your Honor has the discretion to allow me to ask that question, and I would ask for Your Honor to allow me to.
I'm going to allow the question, but I need you to clarify. You're talking about that conversation, and the questions have been on two conversations. So
right.
Ask the question again, and I'll hear if there is an objection.
Mr. Curley, the female prosecutor who was the subject of the armpit hair discussion, did she ask you to get her out of the conversation?
One moment. Mr. Campbell, any question, any objection?
Well, beyond my stated one that it's beyond my recross, in addition to that, that would be hearsay.
Ms. Weingarten, any response?
Well, it doesn't go to the truth of the matter asserted, but it goes to her state of mind that she felt uncomfortable and wanted the conversation.
Hold on. Now, this is Laura, Ms. Weingarten, you and I had a conversation about this. And the agreement was that you would not bring up any issues related to the female prosecutor feeling this, feeling that, feeling that. I've seen no evidence of that. That's garbage, frankly, as an allegation. And you know that. You've never interviewed her. That's in your note to me that she's never been followed up with. That's
okay,
garbage.
Hold on a minute. Hold on.
And you said, I'll tell Joe Curley about this incident that didn't involve him directly. And I said, that's fine. And you said, don't mention the female prosecutor. And I said, that's fine. But here's the deal. Don't be talking about stuff that isn't true about, oh, she felt this, she felt that. Joe Curley can't tell us that. So that's garbage.
Ms. Weingarten.
I want to correct something that Mr. Campbell said. He said that I said that I didn't interview the female prosecutor. That is not true. The memo I sent him said there was no investigation by the Wayne County Prosecutor's Office. She has not been interviewed. What I meant in that memo was by the Wayne County Prosecutor.
If you have interviewed her, I stand corrected on that. It was my understanding that you had not.
Okay, well, I had, and I realize now the memo could be interpreted two different ways. I apologize for that. But
then why isn't she here? That doesn't make any sense.
Problem, Judge, to avoid the problem, I'll just simply withdraw the question.
Thank you. Question is withdrawn.
Thank you.
Thank you. May this witness be excused.
Yes.
All right.
Thank you.
Mr. Curley, we are going to excuse you at this time. Again, the proceeding has not concluded, so you are still under the orders that we discussed earlier and that we discussed when you first testified. Thank you.
Thank you.
All right, counsel, it is 12:02 right now, and it seems that it is the time that we have earlier discussed and agreed that we would take a lunch break if it was at an appropriate time with witnesses, and this seems to be at that spot. Any objections?
No.
No, and I apologize if I was a bit hangry there, so I'll come back nourished and in better circumstances.
All right, we'll see everyone at, let's come back at 1:05. Thank you. It looks like everyone is back. Are we ready to proceed, counsel?
Yes.
Yes, Your Honor.
All right. Your first witness is going to be, is that the chief?
Yes, Chief James Bivens.
I don't see him in the waiting room. Is he there in your second room?
No, let me see what's going on.
I do see your next witness after the chief.
I would say let's go with Ms. Diallo, if she's there.
She is there.
So I have a text from the chief saying having some difficulties with office laptop. Can get there on desktop, but has no video. We need him to have video. So
Yes.
let me see what I can do. I'm going to make some calls while you do the testimony of Ms. Diallo. Is that okay?
Yes.
All right, I'm going to bring Ms. Diallo in then.
Okay, guys.
Good afternoon. Ms. Diallo, are you able to hear?
Good afternoon. I can hear. Good afternoon. Can you hear me?
Yes, I can hear you and I can see you just fine. Thank you.
Thank you.
I'm B Widgeon. I am the appointed master for this matter, and I'm going to start by swearing you in, and then I'm going to read to you information on the sequestration order and the other order having to do with witness protocol. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
So help me. Absolutely.
Thank you. Please state your name and spell it, and then I'm going to go to these other two orders.
Thank you. Lillian Diallo, Lillian. Diallo is D as in David, Iallo.
Thank you, Ms. Diallo. With the sequestration order, it
Judge,
reads,
before we begin, I think it would be helpful if we saw Ms. Jorgensen to make sure she's on and doing her job. Ah, there she is. Okay.
Thank you.
I can hear her. So
Thank
sorry.
you. I appreciate that. And you're the first person I usually look for, Ms. Jorgensen. We can't start without you, but I neglected to that time. So thank you, Ms. Weingarten. All right, so I'm going back to the witness and I'm going to read to you the information with respect to witness sequestration first. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceeding before the master proceedings conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master or the proceeding ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing her testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and from accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or the violation. Do you have any questions about that order?
I do not.
All right, thank you. Also, with respect to the witness protocol, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination, Are you alone at this time in your room?
I am.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in their testifying. Devices that witnesses use to testify, for example, laptops or iPads, must all have notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to any other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you have any questions regarding that order?
I do not.
All right, and do you swear or affirm that you have abided by these orders and that you will continue to do so until the proceeding is over or you are released by the master?
I swear and affirm I will
All
do
right.
all such.
All right, thank you very much. At this time, Ms. Jacobs, I think we're ready for your direct examination of this witness.
Thank you, Judge. Would you please state your name again for the record?
Lillian Diallo.
Would you please tell us something about yourself, your background, your schooling, your family?
Okay, well, let's start with the fun part, the family. I have 3 children. 2 of them graduated from college this past spring, but they couldn't have any ceremony, but that's okay. I have a 16-year-old who we're dealing with homeschooling, and she's a little volleyball project. Oh, she's so great. She's very educated. She's a A+ AB student. I'm loving her. But and then I also have a bonus child. She's been around me since she was 14. She came to the courthouse so that she could be mentored, and it kind of just stuck. So now she has graduated high school, of course. She's graduated college. She is in the military, and she will be going to medical school. If she would have listened to me, she'd have gone before she did this stint, but she is going to medical school at Johns Hopkins. And I have a bonus grandbaby too, and her name is Nyla. She's the best. They're way better than kids. So that's that. And also I went to, let's start with schooling. I've gone to Catholic school my whole life. Then after that, I went to Central Michigan University and got a BS in political science with a minor in business administration. Then I went to Detroit College of Law, which is now Michigan State Law School. And I did obtain my Juris Doctorate. And I have been practicing law for over 23 years. It's been a long time, but it seems just like yesterday.
So you are a Detroiter, is that right?
My goodness, yes, a Detroiter born and bred.
And your office is in the city of Detroit?
Yes, it's in the Guardian Building. I'm downtown Detroit. Ever since I've been practicing, I've always maintained a Detroit presence, and I do have a law office, always have had one down in the city of Detroit, county of Wayne.
Can you tell us what kind of cases you do?
Well, worst cases ever. When we're talking about cases and caseloads, I'm going to do some of the more difficult cases, the homicides, the carjacking cases that can get emotional, but you have to detach yourself and just follow what your charge is. And if my charge is to represent a client, I'm going to represent that client within any and all ethical considerations and the law. So I do the worst cases, homicides, right? I've had one with Miss Weingarten. I had a rape with Miss Weingarten. So I've been around for a while.
Is your practice then largely criminal?
Yes, I do state as well as federal criminal. I do some civil. I started out in the city of Detroit Law Department at first. Doing civil, I would do police misconduct cases, defending, of course, personal injury cases, defending the city, of course. And it was very taxing, and I still do some civil to this day in federal and state court. It really would have to do with the civil rights claims.
You practice in recorder's court, if I can use that phrase. You know what I mean when I say recorder's court.
Every old person like me does. Recorder's court, and now it is called Frank Murphy Hall of Justice. So yes, I'm a recorder's court gal.
In your practice, do you usually see, in the criminal practice in recorder's court, do you usually see the same prosecutors and the same defense attorneys and judges?
Yes, it's an everyday thing. Down when court was open, it would be rare if I was not at that courthouse every single day of the week. I'm also the vice president of the Wayne County Criminal Defense Bar Association. And with that, there are like 400 members, and we have to kind of keep things straight and keep people straight. So I always have the pulse of Frank Murphy as well as membership.
How long have you been the vice president of that organization?
A long time. Over 7 years, I want to say. And this year, I'm running for president. So when we get elections, that's what's going to happen.
Would you rank for us or tell us how important you think your word is in practicing criminal law?
In practicing any law, all we have in life is our word, right? All we have is our reputation, right? And that's what I try to teach the younger lawyers, because I do teach some of the CAP classes at times, some of the brown bags. You as an attorney, you have to survive that particular case. We go on and on and on. Cases have a beginning and an end part, except now during the pandemic. But yes, your word is absolutely important.
Before testifying today, did the disciplinary counsel, Laura Weingarten, ask to speak with you?
She did.
And did you speak with her?
Without a problem. I absolutely spoke to her.
And do you recall when that was?
It had to be last week, sometime. I'm not sure what day it was, but she had reached out, I think the week before. She texted and asked me, could she speak with me regarding my, I guess, testifying in this particular proceeding.
Do you know someone named Anna Bickerstaff?
I do.
Have you had cases against her?
I have had cases against her, and I have, I believe, a couple of cases right now with her ongoing.
What is your opinion of her truth and veracity?
I can tell you this, and I don't say this with any great pleasure. Anna Bickerstaff lied. It wasn't a miscommunication. She lied on me. She lied on me in such a way that it caused a Westland police officer to threaten to do two things. One, put his foot, and I really hate to say this, but I remember this like it was yesterday, up my ass based on something that he said the prosecutor, who was Anna, represented to him, and that would be Officer Richardson out of Westland. And then he also threatened to arrest my ass when I told him, just hold on, we're going to wait in this room for Madam Prosecutor to come in here so that we can clear up this misunderstanding. I refused to leave that room, although I had lots of other things going on, until Anna came down into that witness room.
So let's take this in part. There's an officer named Richardson that you mentioned?
Yes, Officer Richardson. I've seen him around for years, right? Never had a problem with him until one day.
What was the name of the case that this problem occurred?
People versus Joel, Joel Wilson. It was a dope and gun case.
I'm sorry, I stepped on your line. I apologize. It's a what?
It was a controlled substances and gun case. So, you know, it was a real case. It was weight.
You were the defense counsel?
I was.
And who was the prosecutor?
Anna Bickerstaff.
Was this a search warrant case?
It was, and that was the first case I have ever had with Anna Bickerstaff.
Had you filed a motion on this case?
Yes, I did. I filed a motion for Frank's hearing and then also to challenge the validity of the search warrant itself after I read the search warrant and got additional documents from Madam Prosecutor that had not initially been turned over.
Directing your attention to December 13th, 2019, Was that a court date in People versus Joel Wilson?
I believe so. If it was a Thursday, I remember it was a Thursday. It had to be, if it was Thursday, yes.
Can you tell us what happened on that date?
So I was up in another courtroom. It was Judge Noah Hood's courtroom, and I was doing the case People versus Carmack. TV cameras everywhere, and it just went on for a little longer than I thought. But we had called down to the courtroom to let Judge Wanda Evans know I would be coming there as soon as I was done, and that was on the 8th floor. So I get down to the 4th floor where Judge Wanda Evans' courtroom is. And when I walked in, the clerk said, well, we're going to have to adjourn if the prosecutor's not available either. I said, no problem. I said, are the witnesses here? Because we were supposed to have an evidentiary hearing. And the court said yes. Now, when you walk into the courtroom, there was a desk. So the front door, and then there was going to be a desk off to, let's say, the right. There was a deputy seated at that desk outside of the witness room. I said, well, are the witnesses here? He pointed, yes, they're in there, which would be the witness room. So I opened the door. I walked in. I couldn't even get the door did not close. As soon as I walked in the room, the officer said, I'm going to put my foot up your ass. I swear to you, I looked back to see if he was talking to me. I said, excuse me? He said, no, the prosecutor told me that you were talking SHIT about me. I said, what? I said, no. I said, I've been knowing you for a long time. Hold on, let's just wait. This has to be a misunderstanding. We've never had a problem. So I sat there, and there were 3 officers in that room. My eye is jumping now thinking about it.
Name of the officer that you're talking about right now who threatened
Richardson. You? It was Richardson, Officer Richardson. And Laura gave me his first name because, I would have forgotten. It's Christopher Richardson. Okay. So been seeing him around forever. Never had a problem. So I'm sitting down. I'm sitting in that room. Remember, it's 3 police officers. There were 3 white police officers in this room. I decided I'm going to sit right across from Officer Richardson. He just kept talking. I said, let's just wait until the prosecutor gets into this room so we can clear it up. He kept going on and on. Officer Richardson at some point said, yeah, she told me that you said my name, Officer Richardson's name, on the record and that you were talking about me. No, that's not true. I said, why don't we just wait for the prosecutor? He kept going on and on. I said, listen, I want the affiant.
I'm sorry, let me just interrupt. When he was talking about, you said something, Anna Bickerstaff said something on the record about him. You said something on the record about him. Right. Are you referring to this day, December 13th, or are you referring to an earlier day?
It had to have been an earlier, it was an earlier date because the earlier hearing is what gave us the ability to challenge the search warrant in this hearing. So there was an earlier hearing before that, right?
And what department does Officer Richardson work at?
I know he's at Westland. That's all I know.
And when you met him, how long have you known him? Let's start with that.
I'm telling you, it had to be, what, at least 15 to 20 years, right? I've seen him around as long as I've been around, here and there, comings and goings. Say hi, never had a problem.
What department did he work at when you first met him?
At DPD, Detroit Police Department.
Do you know what unit he was with in DPD?
He was kind of all over. They called him Shaggy towards the end. I believe he might have been the gang squad, which also has the tenants with narcotics as well.
Of the 3, do you know the names of the 3 officers in that room?
Compton was another officer, and that was the affiant on the search warrant. And that's who I said I wanted to testify. So I think Anna, I don't know why she would say I said something I didn't say, but Richardson wasn't the affiant on the search warrant. Compton was.
And as the affiant, was he the important witness?
Yes, everything would rise and fall on what Compton had to say. So really, Richardson made himself important for absolutely no reason, none.
Was Compton also a Westland police officer?
Yes, He was a Westland police officer. And the way I knew he had worked DPD narcotics is because it was within the search warrant itself. Appian has this years of experience, you know, had worked narcotics for Detroit. And that same week, there was an article, a big news story that came out about narcotics police officers, DPD, that would have some problems, that were just lying on people.
Did Richardson tell you that Anna used, did Richardson tell you that Anna said that you had mentioned his name?
Specifically, yes, he did. He said that she had said Lillian Diallo, because I said, let's be clear, are you saying that on the record, when I was on the record, Lillian Diallo, said something about you and named you? He said, yes, that's what she told me. And then Officer Compton, who was off to my left, and there was another officer, said, yes, we were in Inkster at the time. And she was there telling us about how you were running your mouth talking about Richardson.
Does this sound like to you that they were sequestered and weren't in the courtroom?
They weren't. They could not have been in the courtroom, because this was to see if they could get, if I could even get a hearing, an evidentiary hearing on that search warrant, and to bring forth the informant. All of that would have happened prior to them being in the courtroom.
Did you ever say anything bad about Officer Richardson on the record before December 13th?
Never, ever.
Had you considered him an acquaintance?
Yes, never had a problem with him. And that's what I was trying to get across to him while we were in that room. And I mean, that was some of the hardest 15 minutes of my life, because it was so combative. It was just coming at me. I said, look, Richardson, I've known you for 20 years. She's been here for 12 seconds, and you would take her word over mine. I've never had a problem with you. He said, well, that's what she said. So that's why Lillian waited right there in that witness room to all the wonderful insults that Richardson had to offer.
Did Ms. Bickerstaff finally appear?
She did. She appeared in the witness room. She came in, and I could see her because she was facing me. Richardson's back was to her. And when the door opened, I don't even think it all the way closed. I said, Anna? She said, yes. I said, did you tell Officer Richardson right here that I said something about him specifically on the record? She said, well, yes, but that was my understanding. I said, wait, your understanding? I said, it was very clear. Allegedly, you told him that I, on the record, said something about him. I said, you need to order that transcript, because that never happened. So she said, oh, it's my misunderstanding, blah, blah, blah. I was so hot. I was shaking, but nobody could see that. And, you know, we went on about our business.
As a result of this incident, have you changed how you interact with Ms. Bickerstaff?
I absolutely have. Anytime I have a case or any interaction with her, we have to do things either on the record. We have to have Zoom. I have to check her file. And I have told on the record, I said, well, Ms. Bickerstaff understands why I have to go the extra step with her. And every case that we have had, and I can give you People versus Javante Wiley, that since then, I will say on the record, I have to deal with Ms. Bickerstaff in a way that covers me. Because if you lie on me, it's no reason other than you thought you could, then I can't trust you. I can't trust you as a facilitator. I can't trust you as somebody that's there for justice, right? You, as a prosecutor, you are not to be someone that just gets convictions. You are supposed to be a minister of justice, right? Not a facilitator of convictions. And what she did in that one case, it was just that important to her. She just wanted her way on that case. That was my first introduction to Anna Bickerstaff.
Thank you. I have no further questions.
Thank you. Are there any questions on cross-examination for this witness?
Yes, please.
Go
Ms.
ahead.
Diallo, the conflict that occurred between you and Officer Richardson in the witness room was over his belief that you told the court on December 13th that a former Detroit Police narcotics officer is involved in this present case, and there have been issues with DPD officers and narcotics officers before, right?
That wasn't what our conflict was about. Our conflict was about Anna Bickerstaff saying that I said Christopher Richardson's name on the record as someone that had done something specific. And I know when I'm making a record what I'm doing. I never said his name. If I was to say a name, it would have been Compton.
Okay, hold on. I'm going to ask you some questions. Just answer the questions.
Okay.
So you believe the reason he believes that you used his name was because Ms. Bickerstaff told him you said that. Is that right? What you believe?
Absolutely. And it was verified when she walked in that witness room and we had that nice little confrontation at the door where I asked her specifically and she backtracked. That wasn't a miscommunication. That was a lie.
Would you agree that if you had said on the record what Ms. Bickerstaff allegedly told Officer Richardson, then Ms. Bickerstaff didn't tell a lie?
Ms. Bickerstaff told a lie. I don't know what you're trying to say. I know what happened in that witness room.
Okay,
I know what happened.
True that you've seen the December 13th, 2019 transcript?
After you sent it to the council, yes. And remember, you asked me, did I have it? And within minutes, you produced it.
All right, do you have it with you today?
It's going to be in my email. Of course, I didn't print it out. I
Right,
remember this day.
I'm going to ask you some questions, and if you don't remember having read it, having said this, then I'll ask counsel to stipulate to it, or we'll have to take a break for you to access your email, okay?
That's fine.
So did you tell Judge Wanda Evans on the record, quote,
Give me the page number, please.
I'm sorry.
Page number, please.
Oh, I'm sorry. Page 14, lines 6 through 11. Ms. Diallo, did you tell Judge Wanda Evans on the record that, quote, part of this affidavit is based on a prior Detroit police officer who worked as a special operations in narcotics and firearms training? There is a significant issue with the Detroit police officers right now and the officers that dealt with narcotics within a certain period of time. And we're just now finding out. Did you tell Judge Evans that?
Absolutely did. Notice there was no name Richardson that was ever named, and that would have been Compton. That was from the affidavit.
All right, so Ms. Diallo, I'm asking you to answer the questions and not add what you want to say, okay? Now I'm referring to page 15 of the same transcript, lines 18 through 22. Is it true, Ms. Diallo, that you told Judge Evans on the record, quote, especially when we now know that there are problems with the affiants and affidavits that Detroit police officers were a part of? A Detroit police officer was part of this one. He now works in Westland, but he used to work in narcotics here. Did you tell Judge Evans that?
Yes, and that would have been Compton, the affiant.
So
of
you
that
were
search warrant.
All right, so let me make sure I've got this straight. You were referring to Officer Compton. Is that right?
Whoever was the affiant, yes, that's who I was referring to. Absolutely.
Would you agree that Officer Richardson also fits that description, that he was a former Detroit police narcotics officer, now a Westland officer?
He absolutely fits it in. I think maybe even the third one that was in there too, but it was specific as to what I said about Richardson.
So, so you may have been referring to Officer Compton, and Ms. Bickerstaff may have thought you were referring to Officer Richardson. Is that fair to say?
I don't know what
I'm going to
Bickerstaff thought.
The disciplinary council is mixed up on when one conversation occurred. The conversation in question occurred prior to December 13th, prior to going on that record on December 13th, and after the confrontation in the witness room.
Judge, I'm confronting her with what's in a transcript. I'm not referring to anything that happened before what was written in the transcript.
But you're assuming that this is why, that this is the point at which Ms. Bickerstaff lied. It isn't on this transcript. It isn't on this court date.
Judge, may I continue?
You may.
Did you hold an evidentiary hearing on January 17th, 2020, at which Officer Richardson testified?
Yes, I did.
And did you confront him with what you characterized as a, quote, misunderstanding?
Yes, I did.
I'm referring to page 58, lines 19 through 21 of the January 17th transcript. Ms. Diallo, do you have in your email that transcript?
I'm sure I do.
Okay. I'm going to read a quote to you and you tell me if this is something you said, and if you need to refresh your memory with the transcript, let us know. This is page 58, lines 19 through 21. And this is your question. And there was a misunderstanding, shall we say, correct? Or maybe not. Was there a misunderstanding in that witness room? Did you ask that question?
I did. It sounds just like something I would say.
And I'm now referring to page 59, lines 10 through 13. Do you recall officer saying that Officer Richardson testified that you had to wait for the prosecutor to come in the witness room and that you asked that question?
If it's in the transcript, yes, and that's true. I did have to wait.
And did you say the misunderstanding was that Police Officer Richardson had been told that you represented to the court that he had been on narcotics with the city of Detroit and that he was part of the problems they currently have, right?
Yeah.
You asked that question?
If I asked that question, yes, but that's what happened. I absolutely asked him.
And in the witness room, Officer Richardson told you that Ms. Bickerson said that you represented to the court that one of the officers on the crew was an ex-DPD narcotics officer, and he's the only person on the crew that used to work narcotics, so he assumed you were speaking of him, right?
Okay, I don't know.
Yeah, I'm going to object. Maybe I didn't understand the question, but I think that she's asking Ms. Diallo what Officer Richardson assumed. I don't think she can testify to what he assumed. Did I misunderstand that question, Ms. Weingarten?
One moment, please. Ms. Diallo, would you agree that it is possible Officer Richardson believed that you were speaking of him when you were talking about a former DPD officer who now works for Westland?
I'm sorry, at what point in that witness room? When I told him I didn't say it, he came at me about what I said about him, not about former DPD cops from from DPD. So no, we had a conversation about what he told me Anna said. And you want to know what was so messed up?
No,
even
no,
after she
there's no
said
question
it.
on the table.
Okay, I'm sorry.
Now, on January the 9th of 2020, Ms. Bickerstaff sent you an email. Do you have a copy of that email?
I think I sent her an email. I asked her for the information. That was the only way we were going to deal. We had to deal by written record. I wasn't ever going to say anything to her outside of some communication that I could document.
So on January 9th, you sent her an email. She responded to your email. Is that fair to say?
Yes, that's fair to say.
And did she send you in her part of the email, did she say, quote, "And I apologize for the miscommunication"?
I asked her for the information and then she responds with that. There's no misunderstanding. It was a lie. So I don't know what she put in there. I asked for information and then she follows up with this whole miscommunication email.
Ms.
So
Diallo,
she had to have a guilty mind.
Ms. Diallo, isn't it true that multiple times you represented to the court in your questions on the record that what occurred between you and Ms. Bickerstaff and Officer Richardson was a misunderstanding?
Oh, I probably did, because you don't say lie in court.
You've answered
I
the
think it's
question.
harsher.
She should be allowed to answer the question. Objection. She should be allowed to answer the question.
Any response before I rule, Ms. Weingarten?
Yes, Judge, she's answering the question and then she's going on in a narrative that is not responsive to my question. I would ask that she simply answer the question.
Right, I'm going to overrule the objection. You may ask the question. This is cross-examination, and I'll ask the witness to please respond.
So, Ms. Diallo, isn't it true that in the January 17th transcript, you characterized what occurred between you and Ms. Bickerstaff and Officer Richardson 4 different times as a misunderstanding?
It could have been, but it was a lie.
And then in the email that Ms. Bickerstaff replied to your email, she said, I apologize, and she called it for the miscommunication, right?
That's what she called it.
And you didn't respond to that email and say to her, it wasn't a miscommunication, it wasn't a misunderstanding, it was a lie. You didn't do that, did you?
I told her to her face. And
Did
I
you do
followed
that?
it up by telling John Casey what had happened.
Did you tell Ms. Bickerstaff in response to her email that it was a miscommunication, that it was not in fact a miscommunication, and that she lied?
I told her that to her face. I wasn't wasting my time with any more communication. The only communication we were going to have is, you do this, do this. That was it. You lie on me one time. That's all you get is once.
Judge, would you instruct the witness to answer my question?
I would suggest that she has answered the question.
Thank you. Ms. Diallo, I'm going to ask Ms. Weingarten to ask her question again, and I'm going to instruct you to answer her question.
Okay.
Go ahead.
Isn't it true that when Ms. Bickerstaff told you, I apologize for the miscommunication, you did not respond to her email and did not say it was not a miscommunication, it was not a misunderstanding, it was a lie?
Objection, compound question.
I can turn it into 3 questions, Judge.
Rephrase, please.
Isn't it true, Ms. Diallo, that in Ms. Bickerstaff's response to your email, when she said, I apologize for the miscommunication, you didn't answer and say this was no miscommunication?
Not by email.
Isn't it true that you never said in response to Ms. Bickerstaff's email of, I apologize for the miscommunication, that there was no miscommunication, this was a lie?
Yes,
Say that.
Judge.
I absolutely told her that. I told her that to her face.
I'll withdraw.
Say it.
Okay, one moment. Was there an objection, Ms. Jacobs?
I'll withdraw the objection, Judge.
All
I'm
right.
sorry.
Ms. Diallo, my question was, did you say that to her in an email?
Oh, no, not by email.
Did you ever correct your characterization of what occurred between you and Ms. Bickerstaff and Officer Richardson as a misunderstanding? Did you ever call it anything else in writing?
In writing, to her face. And then I went to John Casey, the person who was supposedly over her. And how about this? I told Brad Cobb too. And I don't know what any of them did about that.
Judge,
I did tell them.
Judge, I again want that answer stricken as unresponsive. Could you again instruct the witness to answer my question?
All right, Ms. Diallo, I'm going to
Yes,
ask you
ma'am.
again, just to answer the question. If you can answer yes or no to the question that's put, please do so. But
I'm doing my best.
You are
sorry.
you're referring back to something else, but she's asking you just a direct question. So I'm going to respond. Go ahead, Ms. Weingarten.
When Ms. Bickerstaff sent you the email saying, I apologize for the miscommunication, did you ever characterize the conversation between yourself, Officer Richardson, and Ms. Bickerstaff as anything other than a misunderstanding? In other words, did you tell her that was no misunderstanding, that was a lie, and did you respond to her email in that way?
I didn't
respond.
I want to object.
What's the objection?
Judge, there's a conversation with Richardson, and then when Anna Bickerstaff walks into the witness room, there's another conversation in which all 3 participate in. Which conversation is Ms. Weingarten now referring to?
Judge, I'm referring to the email conversation.
But Richardson was not a part of that conversation, so it's assuming a fact, not an evidence.
My question didn't assume he was part of that email conversation.
Please ask the question again, Ms. Weingarten.
Ms. Diallo, did you ever correct the impression in your mind that this was anything other than a misunderstanding in writing? Did you ever say anything other than it being a misunderstanding?
I didn't say it was a misunderstanding. Ms. Bickerstaff did. I didn't even reply to that email because she knew it wasn't.
Well, her email actually says a miscommunication. Isn't that true?
It does.
And your questions at the evidentiary hearing on January 17th called it a misunderstanding. Is that true?
The misunderstanding was between myself and Richardson, based on what Anna said.
Did you ever change your view in writing that this was anything other than a misunderstanding?
But I never responded to her again in writing about People versus Joel Wilson.
And did you ever tell the court or the court reporter that the transcript where you characterized it as a misunderstanding was incorrect?
I'm sorry, you know I didn't get the transcript, Laura, until you sent it to me. I would not have had access to that. I'm not appealing anything. The case got dismissed on my motion, so I had no need to order that transcript.
Having read the transcript now, do you believe the court reporter got it wrong when she wrote down that you called it a misunderstanding?
No, I do not. I'm not saying the court reporter got it wrong. The misunderstanding was what Anna had done right between me and Richardson. Richardson, I gave him an opportunity. I said, now you can say, you know, you're sorry. He's like, nope, because that's what she told me. And she being Anna Bickerstaff.
Could it be that Officer Richardson got it wrong?
Objection to speculation.
Any response, Ms. Weingarten?
I can rephrase the question.
Go ahead.
If Mr. Richardson, if Officer Richardson repeated something he heard Ms. Bickerstaff say and he got it wrong, would that affect your opinion about whether Ms. Bickerstaff is a liar?
If she got it wrong, you said? Yeah, it would have. That's why I waited for her to come down into that room. And once she came into that room, she verified that she had lied on me. She's a liar.
She didn't use the words, I lied on you, did she?
No, you know what she said? She
No,
said, I took it to believe that.
No.
I took it to mean you were talking about Richardson. She told Richardson that I called his name specifically. She said, well, I apologize. That's what she said for telling him that. That's what's not being heard in this whole thing. So I'm sitting, and I had tons of other things to do, Ms. Weingarten, in that building. I took my precious time and waited in a hostile environment.
Judge, would you ask Ms. Diallo again to answer my question and not go off on a narrative?
I'm sorry, Judge, I thought I did.
Ms. Diallo, I am going to ask you to stick to answering the question. I know there are other things perhaps that you could say with respect to it, but just to answer the question that's being asked.
Thank you.
Okay. If Officer Richardson mistakenly believed that you were referring to him, can you understand where he was coming from?
Judge, I'm going to object if this is hypothetical, it's speculation.
Any response?
I think it's based on the evidence. They're obviously not communicating very well.
To the objection that it's speculative, I'm going to sustain the objection.
Thank you.
Ms. Diallo, there were 2 Westland officers involved in your case, both of whom had been Detroit Police narcotics officers and now are Westland officers. Is that right?
At least 2. There was more than that. There were at least 4 officers involved in this case.
And is it possible that there was a miscommunication between you 3 parties, you, Officer Richardson, and Ms. Bickerstaff, about which of the 3 or 2 officers you were referring to?
I'm going to object. She's asking for possibilities. That's calling for speculation.
Any response, Ms. Weingarten?
No, I have nothing else. I'll move on.
All right, thank you.
May I have a moment to consult with Mr. Helland?
Certainly.
I'm going to step out, put it on mute.
Do you want me to put you in a separate room?
No, this will.
All right, 5 minutes. Anything further, Ms. Weingarten? You are muted.
No, no other questions.
Thank you, Ms. Jacobs. Where's Ms. Jacobs?
Yes, thank you, Judge. Miss Diallo, there you are. Can you tell us who John Casey is?
My understanding, he was the supervisor of Anna Bickerstaff.
Can you tell me who Brad Cobb is?
He was another supervisor. I think he was high, he would have been higher than John Casey.
And did you, strike the and, did you go to both of them and tell them what had occurred?
I absolutely did. John Casey saw me in the hall and he came up and started talking about it. But right after that, I saw Brad Cobb. I said, you got a problem in your department. Miss Bickerstaff is a liar.
You said that John Casey came up to you?
He did.
You did not approach him?
No, I saw him in the hall, right? Immediately we engaged about the Anna Bickerstaff issue. And John and I were going back and forth. I said, John, we've never had a problem in all these years, have we? Ever. And this is going to be our problem with Ms. Bickerstaff?
Referring to the December 13th on the record conversation, did that occur before, strike that, did that occur after the conversation in the witness room?
The which one? I'm sorry.
December 7th, and I'm sorry, I got the date wrong. December 13th. Can you tell us the sequence of events between the conversation in the witness room and when you went on the record?
Okay, so there was one hearing, it would have been maybe December, right? The 13th, where you would have a transcript when we were on the record and I'm trying to get my Franks hearing and my evidentiary hearing. There were no police officers there. Between that date and the next date when the case got adjourned, that was when that conversation happened with between Richardson and myself. And I waited for Anna to come into the room.
If that date was December 13th, that's the day of the adjournment and the subsequent going on the record to get the adjournment.
So December the 13th on the record, there was another time when we were not on the record because the case had to be adjourned because everybody was everywhere. That's when the conversation and the showdown happens within the witness room. And then we have the January, I think the next day, the 17th, when Richardson is on the witness stand, as well as Compton.
Was there a misunderstanding between you and Richardson?
It was a showdown. And I know I used that word in that transcript. We had a showdown in that witness room, and that's not what's supposed to happen, ever.
Who was the person that lied on you?
Anna Bickerstaff.
Well, objection, Your Honor. I believe it's hearsay. She wasn't there when Ms. Bickerstaff allegedly lied on her.
But I was there. Oh, I'm sorry. Quiet.
Ms. Jacobs, any response?
It's impeachment.
Ms. Weingarten, any further
Impeachment
response?
of whom? Ms. Bickerstaff wasn't asked anything about what happened with Ms. Diallo.
Anything further, Ms. Jacobs?
No, Judge.
Objection is sustained. Please move on.
When you are in the witness room with the three officers, was the conversation about an earlier court appearance?
Yes.
I'm going to say an earlier court date, correct?
Yes.
And is that the date that you believe that Ms. Bickerstaff made the attributed comments to you about Richardson in particular?
On the record, correct. It would have been the December transcript that everybody, I believe, has a copy of now.
When you walked into the witness room, you had not yet been before the court asking for the adjournment.
No, when I walked into the courtroom, the clerk indicated the case was going to be adjourned. So that's when I went, because I went up to where the clerk was. I didn't get all the way there. And then that's when I went, just as a courtesy, to let the witnesses know, because they were in the witness room for, I believe, a long period of time. So it had to be after 11 a.m. when I went in there. They had been subpoenaed for 9.
The conversation in the witness room was referring to another time, that an earlier date when Anna Bickerstaff was on the record attributing statements to you. Is that correct?
Correct.
Objection to the hearsay unless she was present to hear that in the courtroom.
Well,
I
Judge,
was in the courtroom.
Just a second. Response, Ms. Jacobs.
this is her understanding of what Richardson told her is contingent upon what happened on that earlier date. The lie happened on the, strike that. Anna Bickerstaff made the statements on an earlier date. Ms. Diallo wasn't there, I agree. But she's told that, so it's present sense impression. She's told by Richardson what was said.
It's hearsay. It's an out of court. I'm sorry.
The objection is sustained. Move on, please.
Yes, one moment, Judge.
Certainly.
I have no further questions.
Thank you. Any final questions, Ms. Weingarten?
No.
Thank you, Ms. Diallo. Appreciate that. Is there any objection to, may this witness be excused?
Yes.
Yes.
All right. Thank you, Ms. Diallo. We are excusing you. You may leave. I will remind you that you're still under the 2 orders that we talked about when I first did swear you in today. Thank you.
Will you let me know when I'm not under those 2 orders?
It would be at the end of this proceeding,
Okay.
and we expect the proceeding to last 1 additional day.
Okay.
That's
Thank
the
you so much.
expectation. Thank you.
Everybody stay safe.
Thank you.
Thank you.
And let me see in the waiting room.
I don't believe you have anybody, Judge.
I do not. I do not. Do we need
So
to have,
I'm ready to address the, I guess, order and circumstance of witnesses, if you're ready.
all right, let's take a sidebar and discuss that, please.
Thank you.
We are going to take a 10-minute break at this time and be back at 2:15. Thank you.
Hi, it's me. So anything to report? Right, but they called her. Yep, yeah. No, next is Katrina Bergamo. Bivens is going to be on the 15th, as is Bob Donaldson and Cat. Yes. They're because they ran out of witnesses. They ran out of witnesses. Okay, all right, bye.
All right, I believe that we are all back at this time, and I see that Ms. Bergamo is in the waiting room. We are ready at this time, council, and both, it looks like both council are muted. Okay. Are we ready at this time to call a witness out of order? And that would be Ms. Katrina Bergamo for the disciplinary council. Ms. Weingarten, you are muted.
Your Honor, this is Don Campbell.
Yes.
I do have an objection to Ms. Bergamo testifying. I don't believe that she is a proper, what's the word? Rebuttal. And so I guess I'd need an offer of proof as to what it is that she is going to rebut.
Ms. Weingarten?
Your Honor, the people are calling her for two reasons. First is she was Anna Bickerstaff's office mate, and she was told about what occurred at the prosecution's table immediately after Ms. Bickerstaff came up from court. Counsel has provided in his opening statement and throughout her testimony that Ms. Bickerstaff is a liar. Under Michigan Rule of Evidence 801D1B, the people can present prior consistent statements of a witness made before the motive to lie allegedly occurred. So we're using her for that reason. In addition, in Mr. Campbell's opening statement, he claimed that Ms. Bickerstaff came upstairs to tell her fellow prosecutors about what had occurred. And I believe his words were, she said it loudly and proudly and like a war hero, words to that effect. And Ms. Bergamo will dispute that.
Mr. Campbell, any continued objection to this witness as rebuttal?
Oh, yes. Well, a couple of things. Number one, Ms. Bergamo is on their witness list. Judge, if they wanted to present this evidence, it would have been proper in the case in chief. There's nothing that would have stopped them from doing that. There's no question that Ms. Bickerstaff is a liar. We know that because she admits to being a liar, Judge. And if you remember my opening statement, that's what I said. Because it was Ms. Bickerstaff who said, I knew that there was false information in a report made by Chief Bivens going to Prosecutor Worthy that I let go without stopping. I even had the advice of Ashley Chaffone that I needed to go correct that, and I didn't. We also know that Ms. Bickerstaff is a liar because she told Ms. Weingarten that she had never seen the Bivens report as of September 29th. And we know, because I asked her about this when she testified, that she remembered or realized that Ashley Chaffone was going to testify about that short conversation they had when they walked outside of Chief Bivens' office. And now she was caught. Now she has to admit that she did read the Bivens memo. So all of this came in the case in chief. The time for them to make an action. What witness did I call? What witness did I call that they are trying to rebut? There's none.
Thank you, counselors.
I have more, Judge.
All right, go ahead.
So in addition to that, they say that this is about two conversations. The first one, when she comes up and she says, oh, this is what happened in front of Judge Morrow. We haven't challenged. We haven't challenged a single word that Anna Bickerstaff says occurred in that conversation between Judge Morrow and Ms. Bickerstaff. So there is no purpose there. There's absolutely no, what are they rebutting? There's no, the witnesses to that conversation are Joe Curley, who couldn't hear anything, Ms. Chaffone, who testified in their case. Who else have I called who's a witness to any of that? Then they say, well, what about that second day or the third day of trial? Guess what? We've already laid out that there is a reason for fabrication as to some of the events that occurred within that conversation with Judge Morrow. We laid that out in their case with the difference between what Ms. Chaffone recalls and attests to in her affidavit and those things that Ms. Bickerstaff said in her affidavit. And as I said in my opening, you're going to find that it is Ms. Chaffone who's reliable on those points, not Ms. Bickerstaff. Now, we did call Mr. Noakes to testify, but I don't think Ms. Bergamo can testify to anything that would rebut a single scintilla of evidence that was given through Mr. Noakes.
All right, thank you, counselors. Given the last witness that was presented by the respondent, I am going to allow Ms. Bergamo to come in as a rebuttal witness. Is there anything else before we bring her in?
No, Your Honor.
All right, thank you. I will
Judge,
bring her
can
in.
I just say one thing before you bring her in?
Certainly.
I also want to use her as a witness under Michigan Rule of Evidence 405B about her opinion of Anna Bickerstaff's truthfulness.
Thank you. Anything further, Mr. Campbell?
No, thank you.
All right, thank you. I will admit the witness at this time. Good afternoon, Ms. Bergamo, is that correct?
That's correct, Your Honor. Good afternoon.
All right, are you able to hear us and see everyone?
Yes.
All right, thank you. I am the appointed master in this case. My name is B Widgeon. I'm going to start by swearing you in. And after I give the regular oath, I'm going to also ask you with respect to the sequestration order and the witness protocol order. I'm going to go over that and also get information from you on whether you have followed that, whether you do swear or affirm to continue following that until and unless released or the proceeding ends. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
Thank you. What is your name?
My name is Katrina Bergamo.
Ms. Bergamo, please spell your full name.
First name is Patrina, last name Bergamo.
All right, thank you. With respect to the sequestration order, this order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies unless the witness is released by the master or the proceeding ends. Sequestration includes prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing her testimony in any format or by any means with another witness, from viewing the proceedings on any device, listening to the proceedings on any device, and accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. Do you understand that order?
I do, Your Honor, yes.
All right, thank you. With respect to witness protocol, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room from which you're testifying?
I am alone in the room. My mom is here watching my son. She's in a different part of the house.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond relevant proceedings, exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand that order?
I do.
And do you swear or affirm that you have abided by these orders and that you will continue to do so unless and until you are released by the master or the proceedings have concluded?
I do, Your Honor.
All right, thank you. You may proceed then.
Good afternoon.
Good afternoon.
Tell us again your whole name.
Katrina Bergamo.
How are you employed?
I am an assistant prosecuting attorney with the Wayne County Prosecutor's Office.
How long have you been an assistant prosecutor?
Since 2016.
Before 2016, were you an intern or were you working in any other way for the prosecutor's office?
I was an intern.
Starting when?
I believe I was there for about a year prior to taking the bar and being admitted to practice.
What units have you been assigned to over the years?
I started in the Violent Crimes Unit, or it's known as VCU within our office. I moved to community prosecution in 2019, July of 2019. I was there for 3 months before being moved to homicide, which is where I'm currently assigned.
Do you know Judge Bruce Morrow?
I don't know him personally. I've never had a case assigned to his courtroom. I do know that he is a judge within our building.
Have you ever been in his courtroom?
I have not, no. My only interaction with Judge Morrow was actually this summer through Zoom. I was covering an arraignment for another prosecutor in our unit. And so I appeared before him in Zoom just for an arraignment.
Do you know a young prosecutor by the name of Anna Bickerstaff?
I do.
How do you know her?
I met Anna when I started in the office. She was an intern at the time that I started. And then I met her specifically in the Violent Crimes Unit when I moved there. So back in 2016.
Are you friends?
Yes, we are friends, both in and out of the office.
Are you also office mates?
At the time that I was in Violent Crimes, yes, we were.
Were you office mates when Anna Bickerstaff was involved in trying the case of People versus James Matthews?
Yes.
Did you have another office mate?
We did, yes. His name was Jonathan Mysek.
Okay. Do you also know Ashley Chaffone?
I do.
Okay. When Ms. Bickerstaff was helping try the case of People versus James Matthews, did you see her after court when she would come up in the afternoon?
Yes.
Was there an occasion that you remember any specific dates of when she came up from that case?
I don't remember specific dates. I do remember her doing the case and being in trial and coming up in the afternoon, but I don't even quite honestly remember what month it was.
All right, so when she came up from court, did she share with you what occurred in the courtroom?
Yes.
Did she tell you about something that transpired between herself and Judge Morrow at the prosecutor's table?
She did.
Do you recall what she said about that?
I do. Not verbatim, but generally speaking, I do remember what was said.
Tell us what you remember.
I remember Anna coming up from court, and she said that something had transpired between her and the judge when she was sitting at the prosecutor's table. She said that she had asked for some feedback or something along the lines of getting some feedback regarding her examination of a medical examiner. She said that the judge said he was going to say something that would make her blush. So he came down and sat next to her at the prosecutor's table, where he then basically said that the cause and manner of death is equal to the climax and everything before is considered foreplay.
Did you write down anything that she said?
No.
Did you ever have to make a memo or a summary of what she said to you?
I personally did not make any sort of memo or take any notes. I was interviewed by James Bibbins, who is an investigator in our office. He wrote down everything.
Okay, we're going to get to that in a minute.
Okay.
So do you recall anything else about what Ms. Bickerstaff said to you that day about what Judge Morrow said to her?
Initially, the first thing that she told me was just that. I did subsequently have conversations with her and learned more of what kind of happened during the course of the trial.
Do you know whether you had other conversations that involved other people on different days of the trial?
I was told about some instances that happened with Ashley Chiffone. Just her and Ashley.
Do you know where those conversations took place?
You mean with
respect to the judge and the two prosecutors?
I don't know, no.
Where were you when you had conversations with Ms. Bickerstaff and Ms. Chiffone about what else happened?
We would have either been, Anna and mine, our office was on the 11th floor. Ashley's office at the time was on the 12th floor. It would have been in either my office or Ashley's office.
Were there other people besides the three of you?
I know when Anna initially told me, it was just her and I about what happened at the prosecutor's table. I can't recall if others were present in those later conversations.
Did they tell you about something that transpired in the chambers?
I did learn about more things that had happened between Ashley, Anna, and Judge Morrow with respect to sex and things like that. I don't know if those conversations took place in chambers or if they were in court when it happened.
Were other prosecutors involved in hearing the stories about what happened in court?
I was not. Initially, I wasn't involved in any group conversations. Anna told me privately. I can't recall in the subsequent conversations who was involved.
Were you ever present when prosecutor Bob Donaldson was involved?
No.
Or David Champagne?
There was a point in time when Dave's office was directly next to Anna and my office. When Anna was telling me he did come into the office, based on what he said, it seemed he already knew.
Well, hold on. Don't tell us what he said because that's hearsay.
Yes.
But did he become part of the conversation?
He did.
Okay. Now you say eventually you were interviewed by Detective Bivens?
Yes.
Who is he?
He is the chief of, I believe it's investigations in our office. He kind of oversees all of the investigators.
Was it him that interviewed you or somebody else?
He did.
Where did the interview take place?
That interview took place in my office at the time when I was in community prosecution. I was there between the months of July and October of 2019. I had a single person office, so it was just him and I.
Did he record you in any way?
He was taking notes.
Did you ever get to see his notes?
No.
Did you ever have to sign anything that he wrote?
No.
Were you ever asked to approve what he wrote?
No.
Have you ever seen a report that he wrote that's 9 pages long?
Oh, no.
Have you seen the paragraph of the report that's attributable to you?
Yes.
And did I send you that?
You did, yes.
Have you reviewed that lately?
Yes.
Was there anything about that paragraph attributable to you that was incorrect?
Everything was correct. It didn't exactly lay out kind of when certain conversations happened. It kind of blended everything together, but all the information is accurate. I just wouldn't say that's how I particularly would have laid it out.
All right. Next, how long have you known Anna Bickerstaff?
Since 2016.
You indicated earlier that you're not only both prosecutors, but you're also personal friends?
Yes.
Do you have an opinion about whether she is a truthful person or not?
I do.
I'm going to object. That's not proper character testimony. It's not whether she thinks she's truthful. It's whether you have a reputation.
I can't hear you. I think you're muted.
Any response, Ms. Weingarten?
Yes. When character evidence is admissible, it can be proven by either by opinion or reputation. My hope is to do both with this witness. It is admissible under Michigan Rule of Evidence 405B and 405A.
Further objection or continuing objection, Mr. Campbell?
And to the extent that there's any relevance to a good friend coming in and giving testimony, it could only be reputational, and either she's aware of her reputation or she isn't.
Well, Judge, my response is that both Mr. Fishman and Mr. Edison testified to knowing Judge Morrow for 40-some years as friends, and that they both testified as to his opinion, their opinion and his reputation. So the rules don't change when the other side gets to ask questions.
Well, no change in the rules. There was no objection to those earlier ones. There's an objection here, so the rules don't change just because they didn't object. Again, my position still stands. And again, we don't have somebody who has 30 years of knowing somebody. We have somebody who for 4 years has known somebody.
Thank you. Objection is overruled. I'm going to allow the answer. Continue.
Do you have an opinion as to Ms. Bickerstaff's truthfulness?
I do.
Tell the judge what it is.
I have known Anna to only ever be truthful. I have not known her to embellish or lie. I think she's a stand-up friend as well as a stand-up prosecutor.
Have you talked with your colleagues and other people you know in common about her reputation for truthfulness?
No, I don't think I've ever had a conversation about that.
All right. One moment, please. Oh, have you ever seen Ms. Bickerstaff talk about what Judge Morrow said and did to the prosecutors loudly and proudly as though they were telling war stories?
No.
Thank you. I have no other questions.
Thank you. Are there any questions on cross-examination, Mr. Campbell?
Yes, Your Honor.
Go ahead.
Thank you. You testified that you only ever know Anna Bickerstaff to be truthful. Did I hear that correct?
That's correct.
Okay. You were shown this paragraph from Detective Bivens's report, correct?
Correct.
You were not shown the paragraph that Detective Bivens recorded in his memo concerning the interview of Anna Bickerstaff by Detective Kinney. Am I correct?
Correct. I've never seen anything other than my own paragraph.
Okay. By the way, have you formed an opinion of Detective Kinney, whether she's truthful?
Objection, relevance.
Judge, we have a statement attributed to Detective Kinney. We have it recorded in a memo. We have Mr. Bivens who's going to testify. I need to find out who Ms. Bergamo thinks is credible and isn't credible if she's formed an opinion. How is this not regular cross-examination?
Anything further, Ms. Weingarten, before I rule?
No.
Objection is overruled. Continue.
I'm going to ask the court reporter, Ms. Bergamo, to please reread my question, and then I'd like to take your response.
One moment, please. By the way, have you formed an opinion of Detective Kinney, whether she's truthful?
May I answer?
Yes, you may.
I have never had any close working dealings with Miss Kinney. Her office was across from mine for some time. My extent dealings with her would be just, hello, how are you? I find her to be a lovely person, but that's all I can say. I don't know much about her reputation for truthfulness or anything like that.
Did Anna Bickerstaff ever tell you that Judge Morrow was hitting on her when they had a conversation at the prosecutor's table?
I've never heard those words, no.
Have you ever heard the sense or the general idea that I've expressed in those words?
I wouldn't say that.
Wait, I object. I think that leaves it up to interpretation what a general idea of something is.
Yeah, but it's the witness's interpretation.
Mr. Campbell, I'm going to ask you if you could be more specific in your question, because I'm not exactly sure what your question is.
Sure. Let's put up slide 92, please. Ms. Bergamo, I think on your screen that you're going to be able to see a portion of what we've called Exhibit 12 for identification purposes. It's the Bivens memo that I asked about and that you saw a portion of. This is a different page. This is page 3. Do you see the highlighted portion
Yes,
on that page?
I do.
Okay, and I want you to assume that this is a memo from Chief Bivens to Prosecutor Worthy dated July 8th, 2019. And recorded in there is, as you see highlighted, she added, the she there is Ms. Bickerstaff. She added that she felt Judge Morrow was trying to hit on her because of what he stated regarding sex and foreplay. Do you see that?
I do.
Do you have an understanding of what the word hit means in that sentence?
I do.
No objection, Your Honor. That's dependent on the speaker, not on the listener or the reader.
Again, she just said that she does, Your Honor. This is cross-examination.
Objections overruled. Continue.
So I'm going to ask you to repeat the answer that you just gave because I'm not sure it got caught in the transcription.
My answer was I do. I understand in this context what the word hit means.
Thank you. Can you explain for the record, please, what you understand the word hit to be?
I guess coming on to somebody, showing interest in more of a romantic or sexual way, I guess.
Thank you. So did Ms. Bickerstaff to you relay that Judge Morrow was trying to hit on her, whether or not she used the word hit within the context of what the word hit means? Did she ever say that to you?
No.
Did she ever tell you that Chief Bivens showed her this portion of his report?
No, to be honest, I don't have any knowledge about them Ashley and Anna being interviewed or the nature of their interviews or what was submitted. I don't have any knowledge of that.
Did you ask why you were being interviewed when you were interviewed?
No.
Did you form a belief as to why you were being interviewed when you were interviewed?
Yes.
What was your belief?
Personally, I thought that it was more of an internal thing. I did not know that this was being submitted, that was going to be submitted.
When you say an internal thing, do you mean internal to the Wayne County Prosecutor's Office?
To the Wayne County Prosecutor's Office, yes. I was not at that time aware of what Detective Bivens was doing at the time.
So fair to say you thought this was about an employment situation within the Wayne County Prosecutor's Office?
I wouldn't say an employment situation within our office. I know Judge Morrow is, of course, not employed by the Wayne County Prosecutor's Office. But I did not know at the time that it was going towards what would be a formal complaint.
Did you know that Judge Morrow, let me restate that. Did you think that Judge Morrow was the object of the investigation or somebody else?
No, I understood that it was Judge Morrow.
How did you understand that? Why did you understand that?
Well, based on the fact that I was being questioned in regards to a situation that happened between Anna and Judge Morrow, the context of what that situation was, being a judge talking about sex and foreplay and climaxing and other instances that we haven't really gotten into, but that I am aware of. So I understood that it was about Judge Morrow and what was transpiring during the course of that trial.
But Chief Bivens never told you who the object of the investigation was. Is that fair?
That's fair. It was implied, though.
Implied by Chief Bivens?
Just implied by the course of the interview.
Have you ever, on any other occasion, been interviewed by Chief Bivens?
No.
Did you believe that there was some significance to the fact that it was Chief Bivens and not one of his detectives that was interviewing you?
To be honest, I didn't think that that was odd.
Did Anna Bickerstaff ever tell you that any information that she had given either to Detective Kinney or to Chief Bivens was inaccurate?
No.
Did Anna Bickerstaff ever tell you that she intentionally did not correct false information in a memo that was going to Chief Prosecutor Worthy?
No.
Do you agree with me that if you were to make a misrepresentation to an investigator in your office, it would have serious employment repercussions?
Objection, relevance.
Judge, it's foundational.
This isn't about Ms. Bergamo.
Judge, they've called her, and I need to know what her moral grounding is when she testified to the character of Ms. Bickerstaff. They presented her for this purpose. I should be able to examine that.
You're muted.
The objection is sustained. If you'd like to make a separate record, we can at this time.
I would.
All right, thank you. Ms. Jorgensen, let us know when you are ready.
I will, just a moment, Judge. Okay, the question was, do you agree with me that if you were to make a misrepresentation to an investigator in your office, it would have serious employment repercussions?
You may answer.
I'm sorry, Ms. Jorgensen, can you re-ask that question?
One moment. Do you agree with me that if you were to make a misrepresentation to an investigator in your office, it would have serious employment repercussions?
I don't know what the outcome would be. I know that would be a very serious, I would imagine that I'm not quite sure how my office would handle such an issue. But I agree that it's very serious at one.
I'm ready to go into the main record, please.
All right, thank you. Ms. Jorgensen, let us know when we're ready.
Back on the main record.
Thank you. Continue.
You would agree with me that if a Wayne County prosecutor intentionally failed to correct false information known to exist in a report by a detective of the Wayne County Prosecutor's Office, that would have serious employment ramifications?
Objection, speculation.
Again, Your Honor, it's not speculation. They've offered this witness to somebody to come in and talk about character, somebody to talk about truthfulness, somebody to talk about the circumstances of the Wayne County Prosecutor's Office. This is basic cross-examination to understand how the office works, whether that is something that's of concern. We've had testimony from Ms. Kinney about the emotional state of Ms. Bickerstaff. We've seen Ms. Chaffone show some emotion in her testimony. I should be able to cross-examine whether they are emotional about the employment circumstances or whether they're emotional about something else.
Thank you. I'm going to allow your question and you may answer.
I remember the question.
You said you do remember or you do not remember? I'm sorry.
I do, I remember. I don't know how my office would handle such a situation, but I do agree with you that it would be serious enough for my office to, of course, look into it or do something with it. I agree, it's a serious issue.
Are you aware that in these proceedings that Ms. Bickerstaff has admitted that she saw false information in Chief Bivens's report? Are you aware of that?
No.
Are you aware that upon seeing that false information, she spoke to Ms. Chaffone alone, so the two of them together, I should say, and said, hey, I saw false information in that report. Were you aware of that?
No.
Are you aware that Ms. Chaffone said, you need to correct that? Are you aware of that?
not aware, but that certainly sounds like Ashley.
Are you aware that in response, Ms. Bickerstaff did not correct it?
I'm not aware. No, I have no knowledge about this.
You would agree with me that the kind of conduct I've just described is not truthful conduct.
Well,
I don't
objection,
know.
Your Honor. Wait, objection.
What is the objection?
That assumes that Ms. Bickerstaff lied in that statement rather than that someone else who wrote the statement made an error.
Thank you. Any response before I rule, Mr. Campbell?
Counsel's wrong about that. I'm focusing on the failure to correct. And I'm saying, isn't the failure to correct information you know to be false the same as a lie? I'm asking if the witness understands that concept.
Any further objection or continuing objection, Ms. Weingarten?
No, Your Honor.
All right, you may continue then.
Ms. Bergamo, do you remember my question? Would you like it reread?
Yeah, please reread it.
Thank you.
One moment. You would agree with me that that kind of conduct I've just described is not truthful conduct.
The conduct of not correcting, can you explain or rephrase the question?
Sure. If it's helpful to hear it either again or slightly modified version. Do you agree with me that a failure to correct a knowingly false piece of information is the equivalent of being untruthful?
I don't think it's as easy as saying that. Without knowing the situation or speaking to Anna about it or having any knowledge of it, I don't know what Anna's intention or motive was, or I can't answer that.
Ms. Bergamo, I understand you want to protect your friend, but my question's simpler than that. So I'm going to ask that the last response be stricken and that my question be reread and it be answered.
Judge, I object to striking that answer. She gave an answer attempting to answer his question by saying, I can't answer that. That's a fair response.
Judge, she went on to explain she thinks I'm talking about Anna. I didn't ask her about Anna. I asked her about, do you agree with this concept that a failure to correct something that you know is false is the equivalent of being untruthful?
I will have the witness answer the question as just stated by Mr. Campbell.
Generally speaking, while failing to correct something, I don't know if I would say it's equal to lying, but I do agree that it's essentially putting forth false or misinformation.
Now, taking it into Anna's situation, am I correct that you would see that if somebody else attributed a statement to Anna Bickerstaff and that statement was false, that the Anna Bickerstaff you know would have corrected it?
I believe, yes, the Anna Bickerstaff that I know would have corrected it.
How do you think Anna Bickerstaff would have corrected that?
Objection, speculation.
Any response before I rule on this, Mr. Campbell?
And I think it's fair cross-examination, especially given the testimony of Anna Bickerstaff.
I'm going to sustain the objection. Would you like to make a separate record?
Yes, please, Your Honor.
All right, thank you, Ms. Jorgensen. Let us know when you're ready.
Well, Your Honor, just a moment. Okay, the last question was, how do you think Anna Bickerstaff would have corrected that?
I don't think I know enough about the situation to give an answer as to how Anna would proceed.
Who is Joanne Kinney's boss?
I believe James Bivens.
Who is James Bivens' boss?
I believe Kim Worthy. I think, yeah, I believe Kim Worthy.
And who was Anna Bickerstaff's boss in June, July of 2019?
I believe Anna was still in the violent crimes unit at that time. We did have some switch in supervisors. I don't know if at the time it was Kib Miles and Bob Donaldson or Bradley Cobb. They were both lead attorneys, or all three of them, I should say, were Bob Donaldson and Kim Miles were in charge of the VCU together. Bradley Cobb was before them. I can't recall who was her direct supervisor, but Pat Muscat and Athena Syringas are chief and deputy chief of that unit.
So would that put them above or below the first set of people you talked about?
Athena Syringas would be our chief of the entire Special Prosecutions Division. Underneath her would be Patrick Muscat. And then directly involved supervising the violent crimes unit would be right now, Kim Miles and Bob Donaldson. I'm sorry, I know that was a little confusing.
Oh, no, I appreciate it. I understood it. I'm working on my next question.
Mr. Campbell, do you mean to still be in the separate record?
Separate record currently. I anticipate that's where we'd end up anyway on these questions. So I'm trying to get them all out of the way.
All right.
Do you believe that if you knew of false information on a report created by Chief Bivens that was going to Prosecutor Worthy, that you would have a duty to correct it?
Objection relevance.
Again, we're on the separate record, but that's fine.
Yes, we are. Continue.
I'm sorry, can you ask the question one more time?
I'm going to ask it to be reread by the court reporter.
Yes, just a moment. Do you believe that if you knew of false information on a report created by Chief Bivens that was going to Prosecutor Worthy, that you would have a duty to correct it?
I would say yes. If I knew that there was false information, I would correct it.
Do you agree that if you knew that somebody else had told you there was false information on a report, that you would have a duty to make sure they corrected it?
I think the duty falls on the person who is the false information is attributed to. I think can you ask the question one more time?
Sure. I'm going to ask it to be reread because I think I asked it the way I intended, so I might not get it right the next time.
Just a moment. Do you agree with me that if you know that somebody else had told you there was false information in a report, that you would have a duty to make sure they corrected it?
I think initially there is a duty to correct it. I don't know how many follow-up steps there should be to make sure that something's corrected. I think it falls on the shoulders of the person the false information is attributed to, but I do think there should be some sort of action taken by the person that knows. I just don't know how far that action should go.
So let's put some flesh on this. If I told you that, hey, there's false information going in the report to Prosecutor Worthy, and I know it's false, and you say to me, you should correct that. Mm-hmm. And I say to you, no, I'm not going to. Do you think you have a duty to correct it?
In that situation, I would agree. Yes, if the person is not going to correct it on their own and telling me that, then yes, I do think that I would take the action to alert somebody.
Are you aware of Anna? If we can go back on the main record, please.
Thank you, Ms. Jorgensen. Let us know when we're ready.
We're back on the main record, Your Honor.
Go ahead, Mr. Campbell.
Ms. Bergamo, this may be a repeat of one or more questions from that separate record, but you would agree with me that you have a duty to correct false information if you know of false information being passed within the Wayne County Prosecutor's Office, correct?
I would agree.
Were you aware of Anna Bickerstaff having conversations with anybody at the Judicial Tenure Commission concerning the investigation of Judge Morrow?
No.
Were you aware that Anna Bickerstaff spoke with Laura Weingarten on September 29th, 2002?
No. No.
Were you aware that Ms. Weingarten made a memo coming out of that conversation?
No.
Were you aware that in that memo, Ms. Weingarten recorded that Ms. Bickerstaff told her in September of 2020 that she had not seen or never seen the James Bivens memo that I showed you earlier on the screen? Did you know that?
No.
Mr. Campbell, would you back up for a moment? I think I heard you say 2002.
I think I heard myself say that too. I apologize. I did mean, in my dyslexic way, 2020 when I referred to 2002 earlier, and I think the witness was not confused, fortunately, by it. But,
all right, continue.
Thank you. So you said on direct examination that you only knew Anna to ever be truthful.
Yes.
The next time you're asked, given Anna's admissions that she did not correct the false statement, being aware of it, would you agree with me that you could not testify that way?
I would disagree with you. Without speaking to Anna, without knowing more about it, all I can say is the Anna that I know her to be truthful. I don't know about that situation, and I can't change my answer without knowing more.
Thank you. And you are Anna's friend, correct?
I am.
Thank you. I have no further questions for this witness. Thank you. Oh, I know, I do. I apologize. Did Anna tell you that Judge Morrow was being, let's see what the word is here. Give me a moment. I had it just a moment. I want to make sure I get the right word. That Judge Morrow was extremely mean to APA Chiffon?
I remember that, yes.
Was that after the first day or was that after the second day?
I believe that was in a following, like a subsequent conversation when I started to learn more about what was going on.
Okay, and I don't have any further questions. Thank you.
Thank you. Ms. Weingarten, anything further of this witness?
Yes. When she told you that he was being mean to Ms. Chiffon, do you know if she was referring to the in-chambers conference or something else?
I don't recall how the conversation exactly went. I just remember Anna saying that the judge was being extremely mean to Ashley, seemed to be nicer towards Anna. And I, like I said, we didn't get into certain things that I am aware of, but those were also a part of the conversation.
Thank you. Nothing further.
Mr. Campbell? All right, thank you. Thank you. May this witness be excused?
Yes.
No objection.
All right, thank you. I am excusing you at this time, Ms. Bergamo.
Thank you
There's
very
always
much,
a
Your Honor.
likelihood that a witness may be recalled. But so I'm just saying that to say that the orders that I read to you initially are still in effect until the conclusion of the proceeding.
Of course. Thank
All
you, Your
right.
Honor.
Thank you.
Thank you.
Counsel, given our discussion in at the sidebar last, I believe this is the last witness for today. Is that correct?
Correct, unless Mr. Bivens is available.
It's 3 o'clock. Chief Bivens did tell me he would not be available till 4. So I'm okay with the idea that we do the 3 witnesses on Tuesday, December 15th, and then proceed to final closing arguments at that time.
All right, thank you. That is how we will proceed then. We will end for today. You have the information with respect to the meeting identification for the 15th, and I will see council at that time and the court reporter. Thank you, Ms. Jorgensen.
Thank you.
All right, at this time, I am ending the meeting today, the proceeding. Thank you.